Subject to loss. Whether I'm mentioning what matter, the matter relates to the promotion of a person from the post of the inspector to the higher rank. An application was moved before the Honorable Justice Arindam Mukherjee on 10th of March 2025. No interim order was granted, but there were requests for filing affidavits. Affidavits have already been completed. In the meantime, what has happened was the matter came before lawsuit. It was appearing under the heading hearing. The urgency which I am placing before lawsuit is this. The examination is going to be held from 18th of February. Notice has been already given. What was the
18th February now? How is it possible to take up hearing matters?
I'm submitting before lawsuit.
For all these days, it was not.
The matter had been appearing before lawsuit before the extra citation. It was there in the list. But all of a sudden,
which year it is?
It is 24. It was.
I don't have determination.
Oh,
that is why it is not there in the list.
Yes.
Good. One matter to be for the upgraded this matter, my lord, I have been robbed of 9.5 lakh rupees by the state GST authorities.
Mr. Siddiqui, this week I have not been able to upgrade any matter. Kindly wait for the next week. Next week I'll start upgrading. Let me finish some upgraded matter.
I'll come back.
But this is for upgradation.
Upgraded next week. Next week. I have said that to everybody. I will not make an exception.
Yes. I have given notice.
Yes. Next week I'll take up. I'll finish some matters this week. Next week I will again add up.
Inclusion, my lord.
Inclusion, please.
District.
Yes, inclusion.
But hopefully the previously mentioned upgrade for upgradation, my lord. Next week that will be coming, my lord.
Slowly they will come, because the matters are not ending.
Ordered that to serve upon the respondent number 3, but I'm unable to contact the advocate on record, and she's not even giving the NOC. So I'm just praying that you grant liberty to file a new wakalatnama without the NOC.
Sort out amongst yourself. Matter comes up, you'll see.
My last Friday I mentioned a matter for correction the order, my lord.
Correction can watch na didi.
Thereafter, my lord, I came to note that mentioning slip is not in the court.
Give it again. It is not there.
I mentioned previously also, you said that start taking hearing matters.
I have started taking hearing matters. It will be taken up.
Last week my matters were not there. I have
देखूं तो क्या नो hearing list क्या नहीं होना?
My lord, I have near about 30-35 matters which has not been included in the list, my lord. 23-24 matters, my lord.
Urgent hearing?
No. My lord, inclusion in the list, my lord. My lord, should I give one in one page, my lord?
Please give.
My lord, grateful.
List matters should be listed. They will all be listed. Upgradation is definitely an issue.
I'm for the petition. My lord, the matter is already disposed of. It requires minor correction.
Yes. What is the correction?
In the fifth line of the order dated 24th June 2025, it would be South 24 Parganas instead of North 24 Parganas. And in the fourth page, it would be South 24 Parganas instead of North 24 Parganas after para 7. And in the last, second from the last, it would be South 24 Parganas instead of North 24 Parganas.
So everywhere instead of south it will be instead of north it will be south.
Yes, madam.
this matter has been mentioned for correction of a typographical error in the order dated June 20.
I'm appearing for the petitioner, my lord. Last day,
Yes,
lordship had very pertinently
not
asked-
pertinently, not because of my lack of knowledge.
No,
I
no,
would
no,
not
no, my
like
lord.
to,
It's our
pass an
duty to
order which-
assist. It's our duty to assist, my lord.
Yes,
Let me have that pleasure, my lord. This is the act. My lord will kindly take কোনটা দিলাম?
Four?
কি আছে? Section 4A, first proviso.
4A.
4A, first proviso.
Proviso.
This is a scheme which this is an act which inherently solves the dispute between the two warring parties. 4A, first proviso, provided that the provisions of this section shall apply only where, in respect of an application under this subsection, the applicant obtains the leave of the tribunal or the High Court or the Supreme Court, as the case may be, for settlement of such dispute. So first we have to take the leave. Thereafter, my lord will kindly take section 8, subsection 2, which will be internal page number 9. The first two lines of that page. The designated authority, for reasons to be recorded in writing, may refuse to settle a dispute or rectify or amend the certificate of settlement issued under subsection 1. So they can even refuse to settle my dispute.
So in that case, if it is withdrawn, you become remediless.
My lord. And finally, section 10. Withdrawal of the appeal revision review, notwithstanding anything contained contrary in the provision of the relevant act, the appeal
Shall be deemed to have been withdrawn.
deemed to have been. So this is the.
Yes, Mr. Chakravarti, I am allowing him to approach the settlement commission, keeping the writ petition pending.
Designated authority under the settlement act.
This application, Can 1, Can 1 of 2026. You have a copy of the Can, Mr. Chakravarti?
Yes.
Can 1 of 2026 has been filed.
Service maybe just
Affidavit of service filed today is taken. Can one টা dispose of করে দেবেন? Yes, sorry for having kept you waiting
no,
yesterday for this, but I needed the clarification required
No,
because I am not into this.
My lord,
So,
it is
I will
our
return-
onerous duty to assist the bench. So these sorts of clarifications are always, we are honored, my lord, to have this.
No,
Great.
it's not honored. It may be absolutely childish on my part, but I'll have to do that.
No, my lord,
I will not.
it's
further
always
embarrass
better to
the-
err on the side of caution. My lord. Great.
Yes. Next. লিখে নিন।
And for the respondent number 1, Union of India.
My lord, I am for the petitioner, my lord.
Yes, it was
Yes,
for
my
you
lord.
to come up with. who
Your
is
lord,
the
my lord
authority.
directed me, my lord, my lord, inquire as to whether, my lord, any officer, my lord, is, but I inquired, my lord, from the department, my lord, of the cooperation, my lord. My lord, they say, my lord, that although, my lord, secretary chairman was elected some time back, but that period has elapsed. And after that, my lord, no new election has been held, first of all. Secondly, no administrator has been, my lord, has, my lord, taken charge of the cooperative. Therefore, my lord, as such, my lord, the work, my lord, apparently is, my lord, being continued, my lord, by the erstwhile secretary chairman, my lord, who were elected. But the election has not taken place in some period of time, my lord. That is the information, my lord, I've got.
So what? Merely because it has appeared on so many occasions, I'll dispose it off without deciding what the issue is. What kind of submission, Mr. Kundu? What if you don't want to appear, don't appear.
No.
Then don't make these kinds of submissions.
I'm sorry, Lord.
Yes.
Your lordship, my lord, that is the best I could have, my lord, collected, my lord. My lord, the officers of, my lord, the police station, my lord, on last day, my lord, submitted a report, my lord, that they went there, my lord, and, my lord, served a copy of the application, my lord, on the officer itself. Lordship has, my lord, filed the report. Kindly seize, my
I
lord.
didn't understand, Mr. Kundu, the purport of your submission. It has appeared for 4 times. Therefore, what should I do to dispose this off without the other person appearing? Your case is that somebody else has been assigned the loan, assigned the policy. You don't know the whereabouts of that. He also does not know the whereabouts of that. And I will dispose it off telling what? You suggest an order which can be passed by disposing it off?
No, Lord, sir, I'm not saying so.
No, then what? Why did you make that submission? You are not in a position to shed light on the matter,
No,
and you want
Never,
disposal.
Lord, sir, I'm never before your Lord.
Please don't appear. Don't ask your name to be recorded. If it is becoming onerous on you, please don't appear.
No, Lord, sir, I am not saying so, Lord.
Then what was the purport of saying that?
Every day I appear before your Lord.
So what is the purport of saying that? We are here to decide this. Somebody is not appearing despite police being directed. It is a question of
I
public
know,
money. Then-
I have seen the report, Lord, sir, I have seen the report.
Then you do not know the whereabouts of that person. He is unable to say the whereabouts of that person. I will not be able to decide the issue in the absence of that person. What order will I pass? Merely because you want your fees, I will dispose this off so that you get your fees after the matter is finished. So don't make such kinds of submissions. If you have something to submit on merit, please make your submissions on merit. What is the relevance, Mr. Kundu, of this form that has been submitted by you, page 6? Who is the signatory of this form? Who has signed this? Yes. Yes. If according to his submission, there is nobody who is in charge of that, who is the money going to be paid to, and who has applied? When was this application made? 21st March 2025 is the application made.
My lord, kindly, my lord, takes up the next page, my lord, page number 7. My lord, the entire signature, designation, everything is, my lord, left blank.
What is the credence of this form, Mr. Banerjee, Mr. Kundu? On this basis, how could you say that it has been assigned? What is the basis of assignment? Merely because they say that it has been assigned, you have believed it. How?
My lord, may I indicate? My lord, page number 5, Lordship kindly takes up.
Page 5.
Page 5 is the, my lord, the back side of the policy.
Yes.
There, my lord, there is a recording that it's assigned, my lord, which is in, my lord, not very legible, my lord. That was at the initial point of time, my lord, when the loan was, my lord.
Where is it written that it has been assigned?
My lord, there's a stamp, my lord. Kindly see, my lord. Stamp, my lord, and there's a signature at the bottom, my lord, of the Secretary, Calcutta Telephones District Cooperative, my lord, Limited.
That is there, but where is that assignment thing written?
According to LIC, my lord, this is, my lord, the assignment.
According to them, it cannot be. I have to be shown the assignment.
Yes, my lord, exactly.
That's an order in air.
My lord, exactly,
Where
my
is the
lord.
assignment?
Oh, that is, my lord.
Where is the assignment? Show me. Show me where from you get that it has been assigned. You want it to be disposed of? You tell me how it has been assigned.
Page 5.
Yes.
Page 5.
Page 5 I have seen. Yes, I am at page 5. There is nothing. How do I understand that this is a document of assignment? Merely because somebody has claimed that it has been assigned to him, you will believe that?
In my affidavit.
That affidavit is of no value if it is not supported by the document. Where is the document? To bring that document on record.
Page 5.
Page 5 is not legible. It does not show anything. Show me the word assignment. Show me any line that it has been assigned. I am directing the LIC to hear you as well as the assignee and decide as to who amongst you is to be paid. If you can prove that you have already disposed of the loan, I mean paid off the loan, then in that case you will be given the money. If you cannot prove, then the assignee will, whatever course is to be taken, the LIC.
Well, there will be a third scenario, my lord, where the assignee, my lord, the purported assignee, my lord, does not appear.
If he does not appear, LIC will take a call that he is not interested.
My lord, kindly, my lord, makes that clear, my lord. Kindly, my lord.
I'm grateful, Rashid. May I please your lordship.
Yes.
But proceedings has been started against the deceased father of the petitioner. Malad, kindly take page 26. The deceased father was an employee of NSCBI, Malad, the airport. Malad, a 133(6) notice was served by the authorities to the Malad, the employer. In reply to the notice, the employer intimated, and kindly take page 26.
Page 26.
Page 26, Malad. It is a reply to the 133(6) notice by the employer. Kindly take, Malad, the remarks. In response to such and such issued by such and such Form 16 Part A and Part B salary slip from April 18 to March 19, bank account details of late Piyush Kanti Dev is enclosed for your kind consideration. Please. Further, it is informed that late Piyush Kanti Dev was died on 9th August 2018. That is an intimation by the employer. And the son do not have any knowledge of the notices because he was in Bangalore for his job. He came back to Calcutta in the year in the middle of 2024. But kindly take the 147 order at the page 44. They have considered this reply at page 47. This the order starts from page 44. Kindly take page 47, last paragraph.
Yes.
During the assessment proceedings, a notice under section 133(6) of the Act dated such and such was issued by such and such to provide the complete details of salary income received by the assessee during financial year 2018-19, relevant assessment year 2019-20. Also detailed in respect of bank statement for the year such and such, account opening KYC also short from concerned bank. The National Airport Authority has submitted complete details of salary income on 28 December 2023. But that part, it has been intimated to the authority that the employee was deceased. It is the employee in 2018. There is conspicuously missing, and they are proceeded with. Now, I am covered by your honor lordships, this order. Your lordships, please enough to direct the authorities to start the proceedings de novo if they want to against the the successors. This is an order.
When the proceedings were opened, your predecessor in interest was alive.
No, he was
On
died
the
at
date of reopening also, on the date of initiation, he was dead.
date. Reopening on 2023 and Maladin died on 2018.
But he died in 2018. But I have taken instruction. Lord. My instruction is that never the family members were intimated by the department that they are.
No, but they were you were
That-
intimated prior
that-
to the passing of the order.
that is by the employee.
Very
Yes,
well.
yes,
Whoever
intimate. Yes,
may
yes,
have,
yes. But my lord,
but once it is
yes,
brought to your
and
notice.
yes, I understand. But there are nobody is there in legal heirs. Not they have not made any addition of that
Now you know the legal heir.
Now I know. Yes, yes. Your lordship can pass that
Let's
order. My lord.
proceed
We,
then.
we can. Yes, yes. That can be done.
Yes, Swami. And I have handed over your lordship's daughter, that's
Okay.
enough. Enough.
The lordship can pass.
Yes. শেষ করে দিই।
Both of us remain present.
Yes, good.
But only one thing, for my last,
One thing.
since we have not any affidavit, but I have received the one instruction from the Joint Land Commissioner for the statement of time. But that's
I'll take it on record. I will take it on record and I will record that allegations are not deemed to have been admitted because it's going on only on natural justice point.
Only on
Only on natural justice.
only blacklisting. And it is not in the course, not in the agreement, not in the tender document.
লিখে নিন। Yes, next.
And I am appearing for this one.
Your Lordship, these matters, my Lord may recollect, these are petitions wherein Your Lordship we've challenged the fact that the department has not passed orders giving effect to the orders passed by the tribunal within the statutory time. In these writ petitions, item number 8 to 10, my lord, are identical. They pertain to different years arising out of, and I've divided the writ petitions on the basis of the orders of the tribunal. Your Lordship, in these cases, the department was, the assessing officer was under section 153, subsection 5 of the Income Tax Act. He was supposed to pass orders giving effect to the order passed by the tribunal within the time frame provided under that subsection, Your Lordship. Your Lordship, those timelines have long lapsed. And it is settled law that once the timeline has lapsed, the assessing officer no longer retains jurisdiction to pass orders under the give effect orders under 153(5). And Your Lordship, in fact, my returned incomes becomes final. So he's supposed to now process my return as per my, he's supposed to now act as per my return, and he's supposed to refund at all taxes paid in excess either at the time of the return, during the course of the assessment, or subsequently, along with statutory interest. This was my claim. My lord had previously, my lord, on when this honorable court, if I may say, had on 2 separate occasions directed the department to take instructions. And if I may indicate also, Your Lordship, that in these cases,
Yes,
my-
Mr. Bhattacharya, instructions are there.
But I have taken instruction, my lord. Now, my lord, the assessing officer, my lord, give effect to the order of the tribunal, though, my lord, the proposition of law is not that, my lord, time has been expired. But my lord, I find, my lord, except one assessment here, in all the year, my lord, the assessing, my lord, receiving, my lord, the refund. But this is the, my lord, chart for your lordship.
Maybe, didn't.
if I may have a copy of the chart.
Yes, yes.
Thank you.
Now, we are here, we have 3 writ petitions. One, first writ petition, we have assessment year 2009-10 involved. We have here order passed by the tribunal of 10-10-2018. Order passed by the given order, effect order passed by the AO 24/9/2021, and the order passed by the CPO 28/1/2021. Well, in this respect, we have the page number 3, my lord. In this year, the assessment year 2009-10, the amount of 31,03,630. Minus figure is assess is getting the refund.
Yes.
Now, I believe the petitioner now do not have any grievance against the against as the refund is entitled for the refund, and department has to calculate for that. Now, next
This is not completely arbitrary and illegal. Allow my learned friends to submit. Because if I may indicate 2 things, my lord. But first, if my lord may kindly have a look at the chart, my lord, submitted by my learned friends. My lord, they are passing, but this is where, my lord, in fact, I would
Come back in 5 minutes. Yes.
I don't know. Your Lordship may kindly take the chart once. My Lord, it is very interesting. My Lord, may see the date of the order passed by the transfer pricing officer, the OGE from TPO and OGE passed by AO. My Lord will see the dates as 30th January 2026 in both the cases, and the date of the order of the tribunal, my Lord, is 30th October 2019. My Lord, what has happened, and my Lord, I take great exception to this. My Lord, these orders, these give effect proceedings had become barred by limitation years back, my Lord. We filed the writ petition, we made representation to them on multiple occasions. We filed the writ petition. My Lord, this writ petition was adjourned in 2025 to take instructions. Even on January 27, when my Lord was pleased to hear the matter, our leave was granted to take instructions. My Lord, and my Lord, we have prayed for injunction. I did not press on it under a bona fide impression that my Lord, the department would not do something like this. They passed a give effect order, despite the fact that the proceedings are barred by limitation. The matter is sub judice before this honorable court, and he passes a give effect order when time is taken by the department for the purpose of taking instructions. But this conduct from the department is completely unheard of. My Lord, this way we cannot trust the department. In my so many years of practice, I've never seen something like this sort happening, wherein time is being taken for taking instruction, and the department is misusing that by passing orders. What sort of a conduct is this, my Lord? Then, my Lord, we cannot trust the department on any occasion. And my learned senior, Mr. Bajoria, my Lord, had told me when I had gone to his chamber on one occasion, the department was pressing for stay in one matter or was asking for deposit. Years back, this is a story of 1950s. My Lord, the Honorable Court told the department that he is a taxpayer and he is a gentleman. You are supposed to presume that he is a gentleman and act accordingly. And we presume the same thing of the department, that they will not misuse this opportunity and the leave given by the court. So this order at first of all from item 2 to 2010-11 to 14-15 is completely, my Lord, I would say it is something which is done for the purposes of circumventing these writ petitions. Illegal nonetheless, my Lord. My claim remains. These are barred by limitation. But this act needs to be taken note of, my Lord. How can they do this? And my Lord, as far as assessment year 9-10 is concerned, my learned friend has given me a copy of the computation, my Lord. Now, the order giving effect from the TPO, my Lord, that is item, the first, the last row, my Lord. That is annexed to the writ petition, my Lord. 28 January 2021, I've annexed it to the writ petition because, my Lord, in that give effect order, the TPO himself had given me substantial relief. He had deleted everything. So, I had pointed that out to the assessing officer. My Lord, I had made time and again claims and requests that please give me give effect order. He did not pass any give effect order. Eventually, I claimed that your proceedings are barred by limitation. And, my Lord, I also asked for refund. He does not respond to it. Then, my Lord, this sheet that has been handed over, it is only a computation sheet. It is not the assessment order. And this is unsigned, my Lord. My Lord, may kindly take page 4, my Lord.
Yes.
It doesn't bear the signature. Even if it is a digital document, my Lord, the digital stamp is there. The provisions of the Indian Evidence Act and, my Lord, now the new Evidence Act, it is very clear that digital signature, then there is a presumption. There is no signature on any of these documents. And, my Lord, nonetheless, where is the assessment order? My Lord, this is just a computation sheet. There is no assessment order. The requirement is to pass an order giving effect. This is a computation sheet. So, my Lord, even on this ground, the department can't rely on this computation, in my humble submission, Your Lordship. And as far as the other proceedings are concerned, the law is very clear.
This petition relates to which proceeding?
My Lord, the first writ petition relates to assessment year 9-10, which is the first item in that sheet.
Yes.
And the writ petition thereafter, my Lord, relates to assessment years 10, 11, 11, 12.
Let us go one by one.
My Lord.
Yes.
My Lord, may first take the tribunal's order, my Lord. I'll just directly jump to the tribunal's order and then show the other facts, my Lord. My Lord, the tribunal's order is at page 96 here.
Just the date, because we are not into facts, because that is not in context.
But then, my Lord, if I may just indicate my assessment year 9-10, My lord, my return was filed on 30th September 2009. Thereafter, my lord, the transfer pricing order.
No, the order of the tribunal is dated 10th of October 2018.
2018, my lord.
Yes. Now, what was the time within which it was
Yes,
supposed
my
to
lord,
be
may
given?
kindly just take section 153(5), my lord, for my lord's convenience. Section 153, subsection 5. Is my lord having that provision, madam?
Yes.
Not where effect to an order under section 250 or 254. Now, the order of the tribunal is under 254, my lord. Or section 260, 262, 263, or 264 is to be given by the assessing officer or the transfer pricing officer, as the case may be, wholly or partly otherwise than by making fresh assessment or reassessment. Now, this is not a case of fresh assessment or reassessment or fresh order under section 92 CA, as the case may be. Such effect shall be given within a period of 3 months from the end of the month in which the order under section 250 or 254, etc., is received by the principal chief commissioner or chief commissioner or principal chief commissioner or commissioner, as the case may be. The order under 263 or 264 is passed by the principal chief commissioner, etc. Then I have the proviso, my lord. So, the initial time is 3 months from the end of the assessment year. Now I have the provisos, because I want to show even the extended period, my lord. Assume all assumptions taken care of, even then it is barred. My lord, this order was passed in 2018, my lord, October 2018. 3 months from the end of the month, my lord, means November, end of October, November, December, January. It becomes barred by limitation. Because, my lord, the law is, for as far as tribunal proceedings are concerned, my lord, there is a decision from the Honorable Delhi High Court also squarely on this, which says with the orders, as per the rules of the tribunal, it is either to be passed immediately, my lord, at the time of hearing. If not, my lord, then under Rule 34, read with Rule 40 of the tribunal, it is to be pronounced in open court. So the fact that it is pronounced in open court, it is assumed that the department has been made aware of the order. And therefore, these limitations would operate from the date of such pronouncement. In this case, it is 16th October 2018, your lordship. But, my lord, so my 3 months from the end of that month. Even otherwise, my lord, assuming, my lord, that I need to specifically inform, even then, my lord, I had written. But in fact, the department had passed the transfer pricing reference, my lord, was made in May 2019. So, my lord, even if we take that date to be the correct date, even then, my lord, it is barred in 2019 itself, as per 153(5). Then I have the proviso, the first proviso. It says, provided where it is not possible for the assessing officer or the transfer pricing officer, as the case may be, to give effect to such order within the aforesaid period, for reasons beyond his control, the principal commissioner or commissioner, on receipt of such request in writing from the assessing officer, as the case may be, if satisfied, may allow an additional period of 6 months. So, my lord, therefore, now the maximum period becomes 9 months. Assuming, my lord, he gets that approval, there is no whisper or anything from the department. But by even assuming this period to be true, even then, my lord, the period of limitation has lapsed long back in 2019 itself. Now, my lord, the second proviso, because this is the last proviso available, provided that where an order under 250 or 254 or etc. is required verification of an issue by way of submission of any document by the assessee or any other person, where an opportunity of being heard is to be provided to the assessee, the order giving effect under section 254 shall be made within the time specified under subsection 3. Now, these are not cases of verification. But, my lord, because, my lord, he's not even verified anything in the other years. It is very evident from his new orders. It is, my lord, from the order of the tribunal, it is evident not a case of verification, not made any verification also. But even assuming, my lord, that period is available, even then, my lord, my case is that it is barred by limitation. But subsection 3, my lord, it says, but I'll just give a gist, my lord, of subsection 3 and subsection 4. Subsection 3 says that if verification is required, you get 1 year from the end of the financial year. Subsection 4 says if it is transfer pricing officers, you get further 1 year. So, my lord, cumulatively, maximum period allowed to the department is 2 years from the end of the financial year in which they are made to, they are aware of these proceedings. In this case, my lord, for the first year, my lord, the order is passed in 2018. So, my lord, 2 years would be 31st March 2021, the maximum period available. But admittedly, these orders have been passed on 24th September 2021, barred by limitation on that ground itself. But that order is not available with the department at all. There is no order. Even today, before this honorable court, the department comes only with a computation sheet. And my lord, may kindly take the transfer pricing order once, because this would show the department had knowledge much earlier in 2019 itself. My lord, may kindly take at page 118.
Yes, 118.
But this is the order giving effect by the transfer pricing officer. This is not the final assessment order. But first paragraph it says a reference for determination of arm's length price pertaining to international transaction entered into by the assessment within the proceed enterprises during assessment year financial year 2008-9 relevant to assessment year 9-10 was received from ACIT dated 13th May 2019. But they had knowledge in 2019. Minimum. Till date, my lord, there is no give effect order. And my lord, this order, my lord, is dated 28 January 2021.
No, but this 13th of May 2019, this does not refer to the tribunal's order.
But this is because it's a give effect proceeding, it has to be pursuant to the tribunal's order. The reference can only be made pursuant to the tribunal's order. But paragraph 7 ends in pursuance to the aforesaid direction of the honorable tribunal.
Yes, paragraph 5.
Yes, ma'am. But in fact, I've been given full relief. But these proceedings are clearly barred by limitation as on 31st March 21, as per the limitation provided. Till date, my lord, there is no order. And my lord, I have made multiple representations.
So tribunal's order is given effect to by the TPUs.
But what will happen is that TPU passes the first order. That order is then binding on the assessing officer. He simply needs to give
What is
effect
the
to it.
timeline for the assessing officer to pass order in terms of the order passed by the TPU?
My lord, as per section 153(5), both of them will cumulatively have to do it within 2 years.
No, because the language, if you see Mr. Junjunwala, effect to an order under section 250 or 254 or 260 or 262 or 263 or 264 is to be given by the assessing officer or the transfer pricing officer, as the case may be. Shall effect such period as from the end of the month in which the order under 250 or 254 or 260 or 262. It is only any of these 4 orders upon receipt of which the time period begins to run. So there is no time period mentioned upon receipt of an order passed under section 92 CA3.
My lord, may kindly take subsection 3 and 4 ones, or 153.
3. Yes.
Sir, notwithstanding anything contained in subsection 1, 1A2 and 3, an order of fresh assessment of fresh order under 92 CA as the case may be, in pursuant to an order under 250 or 254, which is our case, in setting aside or cancelling the assessment or an order under 92 CA as the case may be.
This is upon receipt of
254 order.
254 order.
So this is 12 months. 9 months was there.
For the
92
assessing
CA.
officer, for the assessing officer.
92. So I want to bring it stepwise. 1 year is for the CPO, and then another 12 months is for the assessing officer. Where a reference under 92 CA to be made during the course of the proceeding for an assessment. The period available for completion. The period available for completion of case may be shall be extended by 12 months. But he has further period of 12 months.
So 2022 it got closed in that way.
But actually, even the order passed by the CPO is barred by limitation. But yes, my lord, 2022 it got closed. Now, my lord, all that we have is this one computation sheet. There is no assessment order anywhere on the portal. My lord, the department also hasn't provided anything. It is only an unsigned computation.
And what is the What is here now, 2020, it is, this has been given effect to? No,
Which tribunal's order, the TPO's order. Yes. No, that is what we were asking.
that has also not been given effect. Then,
But then I'll, my lord, just take my lord through my letters and also my lord the case laws. If my learned friend wants me to complete my submissions, I'll take my lord through the case laws as well. My lord, I'll just my lord, take my the first letter that I filed before the department. Page 130.
page
130, my lord.
130.
My lord. I mean, just bear with me a little bit. I have a little bad throat.
How long will you take, Mr. Jhunjhunwala? Because it is now converting into a hearing.
No, I will place my submission in respect of interim order placed during the writ.
What
Then
is
my
the
lord, let
interim
me make
order
this
say?
submission.
What is the interim order?
Yes, my lord. That is my lord, page 25, Roman E. Sorry, Roman, not Roman.
Not to make any adjustments.
Now, my lord, if my lord, but what my learned friend says, the department is very bad. But department should not done this because the department taken 2 times, learned advocate of department taken 2 times. My lord, if my lord, on the first day, the interim order passed by this honorable court, what interim order he has prayed, my lord, you'll have to kindly see. Injunction restraining the respondent, their servant agent from making any adjustment to the refund or excess tax for the assessment year 2019 until the disposal of the application. Then my lord, can he say the department cannot adjust, cannot do anything, cannot give effect? He has prayed for the interim order. He has not prayed for. And anything can be made submit before your lordship. But where he has prayed for, even he does, what is his submission? His submission is that the time but all the proceedings time but the department has to make calculation upon his return, not giving effect as such. There is no proceeding. His return should be given effect to calculating the.
Yes.
Now, even the first date, if the department has not taken time, the honorable court giving the injunction in terms of prayer E. Prayer E says injunction restricting the respondent, their servant agent from making any adjustment to the refund of excess tax for assessment year 2019 until for the disposal of the application. What is the word? Has he paid for?
If I may ask for.
Now that all the assessment years I have found, the department has calculated except one assessment year, giving refund to the assessee all the assessment year.
But Mr. Bhattacharya, whether the department had authority still to do it, because in terms of the
maybe not, maybe not. Maybe I am not agreeing to the proposition of law, but I cannot make any submission contrary to the law. But the submission made by Lanet Penam,
that is all courtcraft.
No, not courtcraft. This is the allegation against the learned advocate appearing for the department.
No.
Yes, because what he has said.
But that is
Like he said, we cannot rely.
You are a creature of instruction. You have to take instruction. How will you argue without taking instruction?
Now what instruction I have taken
on that side also.
No, I have taken no. Please, Mr. Junior, please. No, please.
not taking
No. I am only submitting if on the threshold on the date of when the time has been taken before 6 months back, what interim order the court will pass.
Very well.
You should kindly pass the. But my submission is that you should kindly pass the interim order in terms of prayer E. But I will file my opposition to this.
I make few submissions, madam. Just a few, man. Firstly,
Let us answer the point.
I'll be answering to that point. What will be raised by my learned friend.
Not required. We need to answer. We need to answer the point. Unnecessarily expanding the scope of this litigation will not help, because ultimately we'll have to decide whether, in terms of the tribunal's order, effect could be given after the period which has been mentioned in the statute, or no effect can be given at all, and his return itself is to be treated as final. That is the only question which is now calling for consideration of the court and is open to debate. So now you please address the court on that point. That's all.
My full submission without affidavit, I cannot. Because my instruction is not parawise common is required.
So far as the legal point is concerned, what
You also kindly maybe fix for like 2 weeks, 3 weeks, maybe will not. I'm not that will not, but without affidavit, will not, I cannot.
Mr. Jhunjhunwala, since you have waited for this, let us wait for 1 more week or 2 more weeks. Let them come with an affidavit.
Madam, I appreciate I appreciate just 2-3 points, because madam, I think this entire matter is being unnecessarily taken beyond proportion. If I'm not very respectfully, if I may submit, madam, what do my players say, and what does my petition say? That proceedings are barred by limitation, and you cannot make any excessive adjustments beyond my return. Even my injunction preferred. And what is the fallout of the assessment order? That if there are certain adjustments that maybe the tribunal is held against me, then you're passing an order giving effect to that. So technically, man, what is the effect of the assessment order that they will give? They will appropriate certain amount. So it amounts to a breach of that prayer as well. When this entire submission that it is not, that is incorrect. One. Secondly, my lord, with all utmost respect, I want to clarify, and I'm sure my lord also agrees.
Prayer A,
If I may complete,
not his prayer A, prayer B cannot be will not allowed in the threshold of the jurisdiction.
not that.
Maybe will not. He has a good case, but his prayer A, prayer B cannot will not allow in the threshold of the jurisdiction.
I want to complete my one point. I want to complete. If I may request my learned friend not to interrupt, because I did not interrupt it. One simple request that please do not interrupt. And my injunction was asking that no excessive adjustments may be made. My lord, the implication of passing the order is that they may proceed with it and they may make adjustments. So my lord, that submission is wrong at the threshold itself. So my lord, that injunction for not making excessive, passing the order is the first step towards this. That is one. Secondly, my lord, it was never my intention to doubt my learned friend. I will not. He's an officer of the court, and I highly respect him. He's my learned senior also. So my actions were all directed towards the assessing officer that my lord, they have done this behind the back of this. We have done this behind the back. Thirdly, my lord. Thirdly, my lord.
Don't fight amongst yourselves.
Absolutely, I hold him high regard. High regard.
Not fighting, but he's initial submission to that effect that it is the allegation not to the all. Not to the department also, because we are not taking the instruction.
He wanted to submit even
if the calculation has been made, he is saying that will be adjust. That is your future course of action. For the future course of action,
I cannot clarify what he wanted to say by this. He says that
but at the
time when the tribunal passes the orders, the tribunal also may hold against him. If there are certain points in which the tribunal has held against him from which it would appear that money is recoverable from him by the department, then in that case, if this prayer is not made in the writ petition, then in that case, he will go ahead and adjust it. That is why this injunction is required to be prayed for, and that is why he has prayed for. That is his submission.
I mean, even the order, the give effect order that has been passed is the first step towards making those adjustments. So, my lord, when the time limit has lapsed, and I'm asking for an injunction of excessive adjustments, but they cannot completely go ahead and do it without passing the
there should be another prayer for injunction.
Very well. Whatever is there is there. Well, let's come to the meat of the matter.
I agree with my lord. If my lord wants to use an affidavit, my humble request would be that my lord, even earlier, my lord, only a direction for taking instructions was requested and granted. But since direction for request for affidavits are being made, and I completely appreciate my lord the situation that has arisen unnecessarily. But my lord, 2 weeks time may be granted to my learned friend to file affidavit.
Yes,
I will file a reply in 2 weeks.
There is 3 weeks.
3 weeks, my lord. 3 weeks, my lord, to my learned friend.
4 weeks.
My lord, now.
3 repetition.
Similar point. Point is similar.
Similar point for the repetition volume is 2 volumes. One repetition is 2 volumes.
Actually, my lord, the volume, my lord, arises because my lord, I'm annexing the copy to the dispatch.
You take 4 weeks. Finish. How long will you take to reply?
My lord, 2 weeks.
of input tax credit was disallowed on the ground and the supplier has not filed the return by the adjudicator. Thereafter, the supplier filed the return and we filed appeal. Appellate authority rejected the claim on the ground that I could not prove transaction-wise payment by the supplier. So the law does not require me, and there is no mechanism to prove whether the supplier has paid the taxes, the transaction-wise. Moreover, the supplier has filed, it is an admitted fact, the supplier has filed the return in GSTR 1 showing his supply to me. And thereafter, he filed the GSTR 3. There is no one allegation that the figure which has been disclosed in GSTR 3 regarding the total outward supply is mismatching with the total outward supply disclosed in the GSTR. Therefore, one of the legal general presumption is this that the supplier has discharged the liability on the outward supply which has been disclosed to the petitioner. Not only if the liability to pay tax is discharged by the supplier, then there shall not be one disallowance of the claim of ITC. Now, second point, that the learned appellate authority has taken the new point that the claim of ITC cannot be disallowed because I failed to prove the genuineness of the transaction. But this was
not there.
Before the authority, my lord, and
It should be redecided by him.
There are two things. Now get to correction. Today the supplier, the concerned person is no more.
But he was not put that question to. That question was not put to us.
That was not the only contention. Those contention, what was there, this October, we are now left with only 1 month. We are left with August, September, he has been given the benefits. We are left with that 1 month. Now, October, only he had produced it at the stage of appellate tribunal. So, the issues could not have, if we have to be strictly gone by, the issues had to be revived because that was the done at the appellate stage. He had produced the document.
For other 2 months, August, September, if the
Adjudicating authority has passed the order.
itself accepted it, there was nothing which the appellate authority could have done even to reopen it because that was not open before it. That was not the subject matter of challenge.
October, it was during only the appellate stage, only the supplier had filed it.
The October claim was rejected by the adjudicating authority, which is why
not rejected.
all the three were rejected.
No. Out of 3, my lord,
Two were accepted.
2 were accepted because they filed the return.
Returns were filed at the ground. That is what I'm saying. Returns were
So this was only open before
Open,
the
yes, it was
it was not. So for adjudicating that, why should August, September be again reopened? That
He is not a
that is what you were supposed to.
I said, issue was only restricted to October.
October, yes. Yes.
And that was filed during the pendency of the appeal.
Yes.
Now the question is whether that is not the only reason. Can you see the order subject to correction?
No, if that is not the only reason,
There are other reasons.
the other reasons must be stated to him in the show cause also.
That obviously so still to nothing was filed.
Then the appellate authority ought to have given him a response.
I have to see the report.
Mr. Chakraborty, if the appellate authority decides to pass an order basing on a new ground, appellate authority is also equally bound by the provision.
Tax council. It was not in existence at the stage of October. At the stage of adjudicating operation. Can it be criticized or take the order to be bad?
It can be criticized if it does not put the assessee on notice and does not give an opportunity to the assessee to rebut that.
If Hannah sees the reporting, that is not bad.
What is the allegation in the report?
I will see whether the next one told that because 100% argument was that whatever criteria I have put in, it is impossible.
transaction wise,
but that is going to make my understand clear that he has said this in the question. That is impossible. Impossible lays down the principles of section 56 of the Contract Act. My understand is a very interesting term, general presumption. But I don't understand what is general presumption. ITC, the burden of proof is on him.
yes, I have discharged, my lord.
He has not discharged to the satisfaction of the authority. If my lord kindly 61 onward.
'61.
62 minus is the factual and legal background. To note the primary condition that is satisfied by a registered person for granting input tax credit under section 62 of the CGST.
So, but if the relevant return is uploaded during pendency of the appeal, what prevents the appellate authority to take that into consideration? Why? Why will it not be taken?
But kind of here given a reason, and it's not without it. That's what I.
No, that reason must be something which is amenable to reason again. An unreasonable reason will not serve the purpose.
Well, after did not even upload the mandatory evidence at the time of filing this appeal petition in this court. Undoubtedly, these conditions are flouted by the appellant in a manner as opposite with invariably disavow the page category references. The RTP has failed to provide the evidence barring an extract of from which it can be ascertained in absence of other supporting evidence that the suppliers have paid taxes to the government on those supplies which are disclosed by the supplier in the submitted statement. So allegedly disclosed. Most important, as per the information made available detailed email data from the information system of DSA consequence on the requirement of the undertaking to whether the supplier as per the involved as allegedly is clear in the GST or the supplier has been
Mr. Chakraborty, for the earlier months, that is September, August, September, what other evidences had you considered apart from the GST?
That one I don't have this one.
So, why this super technicality here? Because the standard will be the same for every month.
No, we are not able to see the invoices for the cannot. Can you last we may not lose sight of the fact. I can send back the issue, but what are the
Why? I don't find the logic. Why will it not be taken into consideration in the same manner as August and September were taken into?
The only reason for disallowance of my claim of IPC at the so-called stage and the adjudication stage was non-filing of the return. I was never put
Where is the so-called notice?
Well, kindly come to so-called notice at page 29.
that is the fact. He did not file the
No,
return.
sir, page 20. 20.
It's 20.
Yes. Park Vinimate Private Limited, having its principal place of business and property registered under the GST Act, which differs from such and such, and is engaged in wholesale and retail. The RTP has received interest rate inward supplies from Messrs. Mid-District Integrated Peace Limited of Jadpur, Odisha during financial year 1920. From its submitted inward supply registered for the period from August 19 to October 19. It is found that the RTP had claimed the input tax credit under IPS2 Act for the inward supply, the month-wise summary of which is given below. However, Messrs. Mid Integrated Peace Limited have not submitted GSTR for the period from August 19 to December 19, though it has passed on the input tax rate by filing GSTR 1 for the same period. So, the supplier has
Mr. Chakraborty, come to page 22. This is something interesting. That is why
in view of
page 22.
In view of
Just the second paragraph. RTP has prayed to grant them some more time till the supplier updates their return. Right. So this was the issue. Non-updation of the return by the supplier. He does not grant them time. He issues show cause. Right. Now,
After a year one. Yes.
very well. Very well. I'm not on that. I'm not holding it against it. Take page. Take the adjudication order.
page 33 1. 32 1.
Now kindly take page 32.
Considering the request.
Since the issuance of so-called notice, the supplier had filed GSTR 3B
For the month of
however, such and such consequent to the such and such, the claim of has subsequently got reduced.
I understand.
So why different standards?
No,
Why
I think
different
that-
authorities will put
But
different
it
standards?
is also be illogical as an officer of the court, manager for 2 months. I have
You have
delivered the goods. It must be
The
the
only
third one.
allegation against him was that the returns had not been uploaded. Once it is uploaded, you say no, you because of this now,
Now the
not proper. Beginning.
print out.
Page 70.
Page 70 is the order. What
the
was
order.
your report? The order has been passed without giving you an opportunity of physical hearing, personal
No,
hearing.
no, he was
No.
given, what happened was, he was given. On 5th July, he did not appear. Subsequent to that, he has given a reply, where he has asked for certain documents, this document, and says he was given. Thereafter, no opportunity was given. Manoj, kindly come to.
On the pre-show cause notice, I given a reply saying that I required those documents to reconcile statement. Then show cause notice came. And at the date of physical hearing, after the show cause, I did not appear. But in the summons stage and the pre-show cause stage, I have appeared. So 5 times. That has been recorded in the order.
So what happened was page 36, that was the difficulty. This page 36, option for, at the time of uploading the his reply, he had marked no option for personal hearing.
That was automatic at that point of time.
But
That point of time, I defended those matters on that point. That point of time, there's an error in the form. And automatically, NA was
page 23 is the date where I had given him the opportunity for personal hearing.
But the issue was that before at the time of pre-show cause notice, I requested for certain copies of the document seized that has not been handed over to me. That was the crux of the matter.
Page 23, 5th July, fine. The date for hearing was 5th July. And his reply case came subsequent. But I can now Justice Bhattacharya's judgment division bench says, first has to be the presentation, thereafter the hearing. Like written statement, thereafter hearing. On that principle,
Kindly take page 41. That is the reply to the pre-show cause notice.
Page 41 of the writ petition.
Writ petition. That is
And where is his reply after this notice of hearing?
that is also there on record on the writ petition.
Kindly take first page 44. But I have asked for the pre-show cause. Again, after the show cause, I have asked for. Page 44 is the part of my pre-show reply to my pre-show cause.
Page 55 is your reply to the show cause.
Yes. Page 55 is my reply
To the show cause.
to the show cause.
That is dated 6th August 2024.
And the order was passed on?
This order was
Passed on on 18/12/2024.
So after this, no opportunity of hearing.
That's why I said there was some infraction. But he was given prior to this on 5th July, but not after his.
Kindly take page 59, which is the part of my reply to the show cause.
Page 59.
Page 59. Second last sentence. From the bottom, second last sentence. From the bottom. Page 59, from the bottom, the second. Second last, I requested her to supply me a copy of the fees record and return the CPU. In the absence of which, I was unable to file my returns and retrieve documents.
Very good. Any? This writ petition.
Yeah, just one thing, in order to avoid controversy and in order to save time. Appeal of the assessment. But I have understood from the requisition that there is a concluded in specific. So this direction is given to pass order or conclude the appeal. Even in 6 weeks or 8 weeks. All the problems of these assessment. Assessee is 43 as per assessee, 43% of the amount the disputed has been deducted, adjusted. So if the appeal is disposed of, everything will be ordered. This is my understanding. Now it is up to my learned friends.
It is a very, I must firstly thank my lord for making that suggestion, but that would actually not serve the purpose, and that doesn't. If I might just take my lord's order, that had been passed previously, and I'll just say what the controversy is. But in this case, my lord, for the assessment year 17-18, your lordship, assessment order was passed, wherein a demand of about rupees 4.7 crores was raised, your lordship. Subsequently, your lordship, I had filed an appeal, but for the assessment year 19-20, my lord, I was entitled to a refund of about 8.58 crores. My lord, to adjust any refund for any outstanding demand, the department is required to issue a notice under section 245 of the Act, Income Tax Act. Give me an opportunity to object. I object, deal with such objection, and then make the adjustment. In this case, my lord, the first adjustment happened against the refund for assessment in 1920 by a notice under 143(1), which was the processing, not a notice, in fact, the intimation of 143(1) for processing my 1920 return. In that, they made this illegal adjustment of the entire demand at that point of time, which was 4.74 crores. So it was illegally adjusted at that point of time. Subsequently, my lord, a 154 order was passed by the assessing officer, where he enhanced the demand to 10.82 crores, my lord. So the demand now became from 4.7 crores to 10.82 crores, your lord. So the pending amount becomes about 6.1 odd crores. My lord, the department then issued, my lord, a notice of under 245. This is for the first time, my lord. Despite having adjusted, my lord, 100% of the old demand, revised demand, 43%, my lord. But for 23-24, my lord, I was entitled to a refund of about 10.3 crores along with interest. My lord, they issue a notice under 245. My lord, I filed 2 objections, my lord, with the assessing officer. At first objection, I'm saying that you have already adjusted more than 20% of my revised demand. So kindly refund the entire excess in over 20%. Because they can't adjust more than 20%. There are decisions to that effect. I made that public. Secondly, I made another representation on the same date asking for stay of all recovery proceedings, madam. Without passing an order or dealing with that objection, madam, they pass an order under 245, unreasoned, nothing mentioned, and they adjust, my lord, the entire pending amount. Maybe a part of that refund that they wanted to. Then, my lord, they do round 3 of that adjustment, my lord, for assessment at 24-25. Again, my lord, the same actions are repeated. They issue a notice under 245. I raise 2 objections. One, I say that please give me excess of 20%. There are decisions to that effect. Second objection, I say that kindly do not take any recovery proceedings. Again, my lord, unreasoned order saying the portal does not allow for filing of objections or taking the objections on record. They put the blame on CPC, my lord. Very simply and conveniently washing the hands off. And as CPC makes the adjustment. CPC is nothing but an extension of the assessing office. Now, my lord, in this matter, my lord, although the initial adjustment under 143(1) itself is illegal, it can't be done. But, my lord, nonetheless, my lord, as a fair submission, my lord, our prayer and a request to the Honorable Court on the basis of the thorough of decisions, including a reported decision passed by my lord in Gaurav Enterprises, my lord, any adjustment in excess of 20% of the demand in case of an appeal pending before the CIT appeals is contrary to law. So all I'm asking, my lord, is that all adjustments in excess of 20% may kindly be given back to me along with interest. The appeal is pending because my today's CIT appeal may agree with me, I will be entitled to 100%. He may not agree with me, I may take the matter again to ITAT. So that does not mean that the litigation ends there and then. It will continue. Subject matter before my lords is whether they can adjust beyond 20% or not. I had told them you cannot. they still proceed and pass orders. Instead of giving me back in excess of 20%, they continue with illegal adjustments without.
Same matter is being argued at.
Yes, madam, item number 1. Mr. Navinda Senior who is arguing.
Well, there's one decision of my lord where my lord has actually dealt with same issue of Gaurav Enterprises.
Gaurav Enterprises, I was informed it's the wrong decision.
No, my lord. But because my lord, say my lord, I have argued my lord myself a decision called Danieli Enterprises, wherein your lordship, and that matter being led by my learned senior, and that also relies on Graphite India. And my lord, there are these are decisions.
All these were placed. Gaurav Enterprises, I think Mr. Sharma was.
But have you challenged it before the division bench? I do not know.
I don't know.
Because my Danieli has not been challenged.
I haven't got any.
My Danieli, my lord, has not been challenged. Irrespective, my Danieli, India, and Graphite are also decisions of this honorable court. They haven't been challenged. And my lord, there are decisions of JK Enterprises, etc. In fact, there are decisions of this honorable court, which division bench decisions, my lord, which says that 143(1) is not the mechanism for making adjustments. But my lord, we are today, my lord, humbly praying that excess of 20% they can't make adjustments, my lord.
Reading of the circular states though, that adjustments, unless it falls under any of those limbs, BC or whatever is there, where they can appropriate even more than 20%.
My lord.
In meaningful reading of the circular at the threshold, you cannot go beyond that. That is my understanding of the law as of now.
And my lord,
that is the accessory. You can come forward.
Suppose the FSC does not come forward, then also since you have authority to take it beyond 20% only in given cases, that will not apply to only cases where the authority, the FSC has come forward. It is an authority for all, for all purposes. That is how you'll have to read it.
In fact, that is how even my lord, the Honorable Rajasthan High Court in one matter has said.
That is the most plausible way to read it, because otherwise it makes no sense.
Absolutely, your lord. And thus in my case, I stand on a stronger footing because when they issue second and third, if I may just wait one submission, in fact, I stand on a stronger footing subject to my lord, what my lord says. But in this case, first adjustment, nonetheless, your lordship, second adjustment when they wanted to do. But the second part of argument I also have, second adjustment under 245 when they issue the notice, my lord. I filed an objection. And I said that 20% you've already adjusted. Kindly do not make any more adjustments. Plus, I also filed technically a stay before the assessment. And they still proceed to make adjustments.
I was also shown judgments where it was said that merely upon filing of an appeal, an assessee is treated to be not in default.
That is
that is also true, my lord.
If it is not in default, if the assessee is not in default, then your right to realize it will only crystallize upon the assessee being in default. Absolutely. Till such time that the default occurs, the right to recovery will not come.
Now, in section 245, it doesn't provide for this.
It does. 245 provides for a hearing.
And not here.
Without 245 provides for a consideration of the reply.
And that is absolutely.
Provides for natural justice principles being followed.
Only information has to be.
No, this has been expanded by judgment.
Yes,
so that is how it has been expanded by judgment.
But judgment, happens from somewhere and some country. But the final conclusion is all different.
No, man, but that's coordinated in judgment.
I mean, another, the department can set up at this matter, and that other carry forward
that was cited by the others.
And in this case, as well as cited now.
Is there. Just let it back.
No, technically, in my case, I did file an objection. I filed a stay. I told him that you cannot. I made two representations, not one but two representations.
And what about this? He has filed his objections, and you, without dealing with his objections, you have gone on adjusting them.
He's wrong. That I will not deny, my lord, because that is what is in records. But my lord, in the last final that demand of justice, our representation was given, what the assessee has found, that no further adjustments should be.
No, but
No,
last,
my lord,
this
my lord
was
recorded
taken
that
last
this
time.
is considered.
This was recorded in the last.
Page 334.
But my lord,
This is the last one, my lord.
at page 2 or 3, I said, my lord, two objections on the same date. One objection, the objection my learned friend is saying is basically a stay that I was asking for, but I was filing the other thing that you kindly refund the excess beyond 20%. So that is the objection that my lord has also noted in my lord's order on the previous occasion.
That is why I noted, so that I don't forget. I noted everything. Should we wait for that reason also, because both these are on the same point?
I mean, very respectfully, my lord, subject to what my lord, I am not aware of the facts of season. I personally feel, my lord, that as far as my instant case is concerned, I do stand on a slightly stronger footing.
Your case will
as
be
compared
decided
to-
on the basis of your facts. I don't know what more will be shown to me.
Well, I am also carrying various decisions.
So do it. Don't pay.
Because how would my lord want to proceed? Does my lord want to hear Mr. Learned Peanut first, and then
No,
listen to me?
whatever you decide amongst yourself, because it's your petition, it's list, that's not a problem.
Then you
So
know
that we have the opportunity to answer.
For one more day, that's the size of market. That principle is following.
No, if he has some other judgments, that will help both the cases.
That is-
What judgment?
Whether or not I start with Gaurav and decide my lord.
That Gaurav is not a good decision.
But, this was an order passed by my lord, and I don't know why
My order is made.
but according to me, this is in fact the decision is absolutely in accordance with the law, my lord. I don't know why my lord is having any doubt.
My decisions are usually wrong decisions.
No, my lord, my lord, decisions are in fact now being reported everywhere and celebrate. This is a reported decision, my lord.
And nowadays, even affidavit exchange directions are reported. That is what we were discussing on the last occasion when the matter was seen. Even directions for exchange of affidavit matters,
Actually, my lord,
release of matters, those are also reported.
reported, my lord, I don't know when that was.
I've seen many top journals I find.
Because I'm aware of as far as Taxman and TMI and all are concerned, my lord, they only report interim orders if there is a new issue completely and it's something which has not been considered everywhere and stay has been granted. Only then they report. In fact, paragraph 10 onwards, my lord, what
Yes.
is allowed? For the learned advocate preparing for the second parties and considering the material of the court, according to the court has in the judgment of Daniel India, which has been passed by relying on Rafael General Limited, held because the action of the assessing officer in recovering any amount in excess of 20% of the disputed demand pertaining to a given assessment year by way of adjustment from adjusted refund pertaining to other assessment year by an appeal before the Commissioner of Income Tax Appeal. Appealing the assessment order in respect of the said program assessment year is pending cannot be sustained. This court finds no good reason to take a divergency. Mr. Sharma is indeed right in submitting that there is no express prohibition in law for the income tax authority to recover from an excess of 20% of the disputed demand section 296 of the income tax rests exclusion with the assessing officer for not treat the assessee in default in respect of the disputed tax demand. While an appeal is pending before Commissioner of Income Tax Appeal, the such application is guided by the instructions issued by the Central Board of Direct Taxes, to which the office memorandum dated 29 February 2016 issued by CDT was later partially modified by a subsequent office memorandum dated 31 July 2017, instruct that in case where outstanding demand is disputed before the Commissioner of Income Tax Appeal, which is my the assessing officer shall grant a stay of demand for disposal of the first appeal on payment of 20% of the disputed demand. Excepting situations mentioned in paragraph 4B of the said office memorandum, February 20, 2016. If in terms of the said office memorandum, the assessing officer would like to pay the demand upon payment of 20% of the disputed demand by the except in situation mentioned in paragraph 4B thereof, it would be unfair on the part of
the income tax authority to recover any sum in excess of 20% of the demand revenue of agency of fee in the absence of any of the situations mentioned in paragraph 4B of the office memorandum. Now, this is my very an important observation because there is no such indication whatsoever. As regards the judgment in the case of sensitive food industry, super, the notice that the same was rendered in peculiar fact of the case where a notice under section 245 of the Income Tax Act has been issued by the Income Tax Department and where the assessing officer has found the grant of stay was not permissible. In the fact of the Honorable Delhi High Court also proceeded to hold against the authority in the said case of sensitive food industry on being satisfied with the adjustment of the amount was not contrary to the office memorandum dated 31 July 2017 as claimed by the authority. The case at hand is evidently not true. But even in my case, my lord, there is absolutely no whisper anything as far as the documents are concerned. As recorded herein above, the assertion of the revenue authorities is that unless the petitioner puts in a sum equivalent to 20% of the distributed demand recovery of the entire outstanding is impossible. It has not been demonstrated before the court to any degree of satisfaction that any such situation, as mentioned in paragraph 4 of the office memorandum of 29 February 2016, as amended by the office memorandum dated July 31, 2017, exists in the case at hand. In view of such matter, the court is inclined to pass the same order as passed by the coordinate bench of the state in Bangalore, India, by relying on graphite India. Thereafter, the direction has been issued in the case. So, my lord, this is the first decision. Thereafter, my lord, it would my lord want me to also place the decisions of Danieli, India, and graphite.
Those were cited in this case,
my lord. Then, my lord, I'll take my lord one through the decision of the Honorable Rajasthan High Court in case of Rajendra.
like this in the original statement.
So, this is cited now.
Both graphite, Danieli, this Gaurav, this Rajasthan, everything was lot of there is a bunch of judgments.
Then
Delhi High Court, Rajasthan High Court, then Mr. Jaspal cited that Madhya Pradesh, Chhattisgarh,
Northern Kosi.
then the SLP being dismissed.
Because, my lord, as far as 20% is concerned, my lord, now the law is such that even the tribunal, my lord, if the matter is before the tribunal, even the tribunal is to grant me a stay of the order, my lord. My lord is aware, my lord, that the power of the appellate authority, while considering a stay, is much wider than the assessing officer. The assessing officer only sees whether he can treat me as an assessee in default. And the appellate authority sees whether the order, ensued order needs to be stayed, and all effects arising thereof. Even now, the tribunal is empowered to grant a stay on the operation of the appellate authority, and my lord, the order of the assessing officer having merged into the order of the appellate authority, my lord, once the Commissioner of Appeal passes the order, the tribunal will stay such appellate order if 20% is deposited. So, my lord, even if we take the suggestion given by my learned friend, let the Commissioner of Income Tax Appeal pass the order, but he cannot firstly pass an order randomly. He has to give me a new hearing because more than almost 1.5 years have passed since the last. Irrespective of even if he passes the order against me or in my favor, my lord, still assuming the worst against me, I will prefer an appeal, my lord, so the list does not come to an end. And even in appeal, my lord, I'm required to pay 20%. And they've recovered more than 20%. So anything in excess of 20% ought to be refunded. I'll just place on the question of the Honorable Rajasthan High Court. My lord feels that I'm being repetitive.
No.
Then in that
Not in this case, so that the records of that case will be with that case only. Here, if you have to cite, to cite.
At paragraph 6 onwards, after considering the records of the writ petition hearing arguments advanced by the learned counsel for both the sides and also considering judgments cited by the factor at the bar, the observer under the assessment order under section 143 of the Income Tax Act was passed and the demand was raised under section 156. Simultaneously, for the assessment year 2017-18, for the demand of tax to the tune of rupees 2,944,100 in the specified format of notice of demand under section 156 of the article specifically submitted, the recovery proceedings will be carried out in case of default and non-payment of within 30 days under the provision of section 322, 227, 329, and 252 of the Income Tax Act. It is mentioned at the said notice under section 166 that an appeal can be preferred within a period of 30 days. The same is reflected in the notice of demand dated 13th December 2019. It is also admitted that an appeal under section 246 of the Income Tax Act, read by 245 of the Income Tax Act, is filed in the prescribed Form 35, December 26, 2019. As per the provisions of section 220, subsection 6 of the Income Tax Act, which provides that the assessment cannot be termed as an assessment in default when the provision is quoted. Where an assessee has preferred an appeal under section 246 or 246A of the assessing officer may, in his discretion and subject to the conditions of the state, to impose in circumstances of which treat the assessment as not being in default in respect of an amount which is in amount and dispute in the appeal, even though the time for payment has expired, as long as such appeal remains undisposed of. The respondents have also issued an intimation deemed to be under section 245 of the Act on January 13, 2020. The provision of section 245 of the Income Tax Act, which is recently below categorically specifies that as per the principles of natural justice before reduction the refund, the assessing in default and intimating and banking to such person of the action proposed to be served, and after section 245 is quoted. In response to the said intimation under section 245 of the Income Tax Act, the petitioner filed an application for stay of demand, which is reflected in the letter dated 22 January 2020. It is also reflected that the petitioner, assessee in terms of the departmental circular, has voluntarily requested the department for adjustment of 20% of the demand to the tune of 41,88,670 from the refund, and the balance amount to be refunded. It is analyzed that the order of the provisions of section 245 section 6 of the Income Tax Act, respondents are so much adjusted the entire amount of refund to the tune of 70,36,950 prior to the assessment year 2018-19 on December 13, 2020, making the provision of section 220 of section 240 of the Act for member and anti-formality. Further, the prejudice against the petitioner has been taken in violation of principles of natural justice. Same as my case. The high-handed action of the respondent is also reflected in bypassing the said application for the assessment of 2019 as refund of rupees 32,32,062 was again suo motu adjusted on February 25, 2020 by bypassing the fact of filing of the appeal as well as the provisions of section 245 of the Act. The petitioner, in support of the erstwhile application for stay dated 22 January 2020 again filed stay, which was also not considered. Finally, the petitioner filed an application on 22 February 2021, being actually of further recovery by specifically mentioning provisions of section 220 of the Income Tax Act on March 23, 2021. The respondent granted stay on the recovery of the balance till the disposal of the appeal. The case on hand is a classic example of absolute power corrupt absolutely. The petitioner assessee was quite prompt in filing the appeal under section 246 of the Act, Income Tax Act, against the order dated 13 December 2019 without waiting for 30 days of statutory time. He filed the appeal on merits in the prescribed format on December 26, 2019. It is a fact on record which is admitted by the respondent himself that till date the Commissioner of Income Tax fees, for the reasons best known to him, has not considered the said appeal which is beyond the control of the petitioner. But identical facts in my case, I also filed the appeal within the 30 days, in fact, slightly before the 30-day period, and Commissioner of Income Tax Appeal hasn't disposed of my appeal.
And when was your appeal filed?
My appeal was filed on 24 January 2020. Yes, my appeal order is 27 December 2019, and I filed my appeal on 24 January 2020, less than 30 days.
5 years.
Document everything has become faceless. So I have this endeavor that it is taking a toll on the department.
That is also long gone. Long gone.
But now what they've done is that they've given power.
This was also during the COVID only. This appeal was filed on December 26, 2019. The order is of 2022. So this was more during COVID, my lord.
My last hearing matter happened, the video conferencing happened before the authorities on 7th August 24. Okay.
5 years is a long time. Bid has also gone in 2020. Thereafter also 3 years have gone.
It's piece of season to season. KIT appeals. We have no control, man, and they will keep adjusting. And we will write notices, write replies, they will adjust. We have no hearing. And it is becoming, man, it's easier to season exercise, man. Other case, my lord, had seen order, man, despite the pendency of the writ petition, man, they're passing the orders, man. I don't know what the income tax department is doing. But my lord, what is not in this case, not in this case. I'm not talking about other cases. I don't want to get into the fact, but my lord, what's the RSB? Let us continue with the state law. Yes. Paragraph S, my lord, if I may again. If
the case on hand is a classic example of accurate powers there are actually clear. The petitioner was quite prompt in filing the appeal under section 42 of the Act against the order dated February in 2019 without waiting for the 30 days statutory time. He filed.
I have read it.
So I will view on that. In fact, here is one observation comes at the middle paragraph. In spite of specific statutory provision under section of the Income Tax Act that on filing the appeal in the prescribed format, the petitioner assessment will not be
considered as assessee in default. Now, this is my lord, what had fallen from my lord earlier.
given or go by the statutory provisions contained under section 220 of section 6. Income Tax Act, giving an intimation under section 245 of the Income Tax Act for claim of refund against the outstanding demands. The respondent has failed to consider the response, rather has given a speculative argument to the said application cannot be made after section provisions of section 226 of the Income Tax Act. Nowhere in the provision of section 220 of section 6 of the Income Tax Act is specified which two applications have to be made. The mandate of section 220 of section 6 of the Income Tax Act makes it very clear that once an appeal is filed within the time prescribed, within time in the prescribed format, the assessee will not be deemed as an assessee in default. Further, the notice under section 156 of the Income Tax Act categorically specifies the demand for only be made in the case of default under the provisions of section 222, 223 of the Income Tax Act, which is not, which will not be made out. It is also analyzed by the court at the time, and when we continue, whereas various high courts reported in, but in various descriptions of the of the Honorable Supreme Court. But page 29 held that under section 345 of the Income Tax Act, the recovery can only be initiated after giving an information in writing to the assessee of the action proposed to be taken under the section. Not following the mandatory requirement of information under section 348 of the Act. And also not following the principle of method that was illegal
without authority and unjustified.
Further, the government suffered about have categorically held that when an appeal of the assessee pending and the claim is not disposed of for reasons beyond the control on account of apostolic authority and administrative concerns in the part of the respondent, the recovery of demand pending the appeal will be an act in terrorism. The owner counsel for the respondent ready was not able to reflect why the appeal was not disposed of promptly, nor was he able to refute the fact that under section 1 filing of the appeal, the petitioner was not to be treated as an exceptional default. The recovery taking place is beyond the provisions of section 275 of the Income Tax. Learned counsel for the respondent ready only of the title and contended that the application for stay under section 220 of section 6 of the Income Tax Act was only made on February 2021, and thereafter the stay of demand was made. In this context, it is important to note that unlike the provisions of section 129 of the Customs Act and the provisions of section 235 and the requirement of redeposit to entertain an appeal, it is only by administrative CR under the Income Tax Act that the provision of stay is granted. The demand of 20% is made. If the demand of 20% is redeposited, the office of the government sometimes agreed about meaning thereby that without a statutory CR, power and authority of law of this memorandum are issued. The respondents have failed to consider the provisions of section 320 subsection 6 of the Act. Thereby, on filing of the appeal, the assessment will not be deemed in default. The recovery action as per section 222 and 223 of the Income Tax Act can only be initiated by the tax recovery officer. The adjustment from due refund can only be carried out after serving intimation and giving opportunity of hearing as per the provision of section 240 in a cantina of statistics. But thereafter, I wrote, and the line is the question of Hindustan Union the Honorable Bombay High Court.
In this case, I rely on paragraph 14 and 15 of page 287 on. Page 287 onwards, my lord, paragraph 14, 15.
Section 245 of the Act empowers the revenue to adjust, refund, duties, and assessment against any tax of the same character as the refund is due for him. The exercise of this power is discretionary as is evident from the use of the word made therein. Besides, the requirement of giving notice of implementation of the proposed action of adjustment of the refund due is also an indication of the discretionary power, not mandate. This notice information is required to be given so as to enable the party to point out and not only any factual errors, but also point out why such a power should not be exercised in the facts of the case. Such as the demand sought to be adjusted is still a subject matter of an appeal. On consideration of the same, it is open to the assessment to the officer and revenue concerned to adjust or not. This prior information has been held by this court in AN case versus Suresh B. Done, the 2031 before any adjustment can be made. The exercise of powers under section 245 of the Act being discretionary has also been held by the court on reported assessment. We respectfully concur with the view of the Honorable High Court. The power under section 245 of the Act is discretionary. Thus, the exercise of power of adjusting demand out of refunds due would depend upon the facts and circumstances. In view of the private court aims to secure the giving of prior information under 245 Act is mandatory. The purpose being to enable a party to point out that there are factual errors or some are further development. For example, a stay in the demand, the Supreme Court decision covering the demand, which is to the subject matter of a pending litigation. If that is not adjusting the refund against the pending, thus where a party does raise such issues in response to a prior information, the assessing or the officer of the revenue exercising the powers under section 245 of the Act must apply his mind to it and must record reasons why the objection is not sustainable and also communicate it to the party. This before or at the time of adjusting the refund. This alone would ensure that the power of adjustment under section 245 is not exercised arbitrarily. Such a procedure would cause no prejudice to the revenue as the occasion to grant the refund would not control to the objection to the information is disposed of. Of course, the objection should be disposed of expeditiously and only granting of the refund would cause prejudice to the party entitled to the refund.
But in this case, there is absolutely unapplicable to my. I made objections not confirmed.
Then there is a decision of the Honorable Delhi High Court
in case of skyline engineering.
My family promise to happen.
Yes.
But if my room may kindly take I just quite quickly to draw attention of my lord to one fact that here my lord that office memorandum of 29 February 2016 is placed at page 278. Whether 20% and 15% of that is placed. Thereafter, my lord, when the honorable Delhi High Court starts considering that from paragraph 9 on. This is very interesting. Yes, having heard the counsel for the party, this court is of the view that the government is bound to follow the rules and standards they themselves have set on pain of their action being invalidated. This court is also of the view that the office memorandum dated 29 February 2016, the office memorandum of this 2017 stipulates that the assessing officer shall normally grant stay of demand till disposal of the first appeal on payment of 20% of the disputed demand. In the event the assessing officer of the view that the payment of a lump sum amount higher than 20% is warranted, then the assessing officer will have to give reason to show that the case falls in para 3 of the office memorandum dated 29 February 2000. This court finds that in the present matter, no order has been passed by the assessing officer under 245 of the Act for adjustment of the fund. Moreover, there is no order of the assessing officer giving any special or particular reason as to why an amount in excess of 20% of the outstanding demand should be recovered from the petitioner assessee at this stage in accordance with paragraph 4B of the office memorandum dated 29 February 2000. Consequently, this court is of the view that the respondents are entitled to seek free deposit of only 20% of the disputed demand during the pendency of the appeal in accordance with paragraph 4A of the office memorandum dated as amended by the office memorandum dated 25. Well, in this case, there are paragraph according to point number 1 is directed to refund the amount adjusted in excess of 20% of the disputed demand for the assessment year 2015 and 16 within 4. But in this case also, when I had made those representations, he doesn't ever say as to why my case, this decision shows that when the assessing officer is making an adjustment beyond 20%, he needs to give reasons as to why he's making my case is falling under 4B. And nothing has been done. So, in my humble submission, firstly, even the 143(1) adjustment is illegal, cannot be done without authority. Nonetheless, they've done it. But subsequently, when they propose to make further adjustment, this time by issuing 245 notices, where I'm making the submission to them that please, you've already adjusted down, the revised demand is now 43%. Earlier it was 100%. Then because of my that 154 order, it becomes my 43, 44%. They're making that submission to them that you've already adjusted beyond 20%. Kindly return the entire additional amount. Plus, I'm also filing a separate stay application or making a representation for stay of not making any further adjustment. They don't consider it. It is not a speaking order, the 245 adjustment. They're not dealing with my request of refund of the excess amount. And my lord, they unilaterally just pass an order, unreasoned one, and they make the adjustment. And they've not just done this once, they've done this twice. So, my lord, the actions of the department in this case, my lord, is completely arbitrary. And my lord, there are further discussions, my lord, if I may submit, my lord. How long will you take, Mr. Engineering? Well, I have my around 4-5 decisions to show. My lord wants to first hear. My decisions are on these lines. My decisions are on these lines that I would only want to then place one decision of the honorable my lord of this honorable High Court, wherein your lordship this point has been taken that in 143(1) intimation is not the way to make adjustments of refund. But my lord, my challenge, my lord, but since they've made that adjustment in 20%, all I'm saying is that beyond 20%, kindly refund. That is correct, my lord. And 20% they can't, my submission, my lord, would be that 143(1) intimation is making an adjustment through that is illegal. Nonetheless, I've asked for more than that refund me the amount in excess of 20%. They passed and they issue notices for the first time under 245 on 2 different occasions.
I file objections to such notices. I tell them to kindly refund in excess of 20%. They don't consider such representations and they continue to appropriate sums constantly. So my the second limb is that even these adjustments under 245 are illegal and in gross violation of principles of national justice. Well, as per the Delhi High Court, my lord, since those adjustments are non-speaking and are in excess of 20%, they should be directed to refund the excess amount. And then if they want to make adjustments, let them do it in accordance with law. Yes. Okay.
I have you have already what we need the proper because my lord, if you have to if the department has to record, exactly but you have I guess why this kind of problems are arising. But all FSC is always putting blame on the that department has not done that, What the FSC has. It is well known to the FSC. It is not an individual. That is not aware. So an individual comes forward and says, no, I was not aware. Understand. It's a multinational company, it's one company. He is all aware of what is the law. SSC allowed never challenge. That deduction, the initial deduction, that is never not filed any statement. As soon as the SSC is filed, to the file a petition to the or to the commissioner of that let if order is demand be stayed and pay matter would have been engaged. But SSC did here malady what I have understood. I can find human interference is function of system. What is on the system? Accordingly, if there is no order of sale, the system will say no sale. So what will the replace? What action will the officer will take? What action the CPC will take? There is no order, so you are entitled to deduct.
No, but then the system has to be amended. And system is under the control of human beings. The day when system will start controlling human beings, everything will go haywire.
In several cases, my other cases, the FSC are taking on other matters.
That is now becoming sort of recourse for the human agencies to abdicate duty. That should not be allowed to be done. Merely because there is a system, therefore I attribute guilt to the system and I remain unblemished. That
I'm not.
it is becoming a way to whitewash your conduct. That can't be done.
But taking advantage of their own wrongs.
That can't be done. If there is something which is going wrong with the system has to be amended because this is not for the first time that it is coming. At least in this, there was graphite, there was Daniel. Even then there were systems when the earlier judgments were delivered by this court. Similar kinds of arguments were submitted advanced even then. Today, so many years down the line, if we are at the same stage, then it is no good blaming the system anymore. It is the person who is manning the system who is at fault. That won't serve the purpose. That won't serve the purpose of the SSC. Somebody who, as a litigant, if a litigant approaches court, they will have to refund every time. Then that will be the court. They will learn it the hard way. It is not easy always to put it on the court that you invite order from the court sitting here will run the administration. That is not how it is done. That every time I will ask the system to be corrected, every time I'll ask you to do what was doable, what was supposed to be done by you in accordance with law. If you are lax in doing that, you will do it by orders of court because you have done it earlier also. You are supposed to give reasons, you will not give reasons. You are supposed to wait for a particular time. There is a provision, there is a statute. Merely because there is a system, you have authority to overreach this statute. That cannot be permitted. That's not right. This kind of attitude will always lead to these kinds of orders. Not safe.
And if I may submit my report,
Because I could have understood if this was a one-off case. Now it is becoming a run-of-the-mill case. Every case is of the same nature. Cyclo-styled orders, cyclo-styled stands. There was some law point, yes, understandable. Not right. And this is not happening only here, it's happening everywhere because there are judgments across the country of various high courts. You have Delhi, you have Bombay, you have Rajasthan, you have Calcutta. How many more you want? All speaking in the same tune. It cannot be the fault of the system alone then. That is what it shows. Will be difficult for you to override so many authorities and hold something which is absolutely different from what other authorities have consistently held, unless it is a question of law, where you have some elbow room to differ. Here you don't have. It is clear, it has been explained, accepted by this court in earlier judgment. I will have to follow. What to do? 10 more minutes to go.
well, just to add my add-on, but CP have all the provisions in the act. They assessing
You have
officer-
the Daniel and graphite also.
Yes, sir.
So give that also survey, cite it formally so that we keep it on record. This paragraph.
My graphite, my please take some to an earlier discussion about. But paragraph 9. My road has paragraph 9.
Yes.
Mr. Gopal, when added to the appearance of the defendant of freedom of investigation submitted under section 645 BR, there was no provision for granting of hearing before taking action of adjustment, and it was not mandatory. We also submit that the whole issue referring to the assessment of 2006 in the pending appeal before the Commissioner of Income Tax period include action under section 348. I am not convinced with the argument and submission of Mr. Gupta in view of the evidence stuff is recorded above. And the law laid down the appropriate judgment that the foreign opportunity of hearing to be assessed to person under section 345 of the Act. And the information of proposed adjustment is a mere evidence format. More so, when the petitioner is already filing a testing against the proposing adjustment of refund from the due of another assessment. The respondent assessing officer was bound to dispose of the same and to take a decision on the fair objection. Mr. Gupta could not satisfy the court from any record if any formal order was passed by the assessment officer on the objection. He reached a positive information against 45 right? And specifically recording a satisfaction with the demand and threshold cannot be recovered at all. The country was settled to concluding that the were not to pay the amount of demand. Mr. Gupta also could not satisfy from the record that any specific order was passed to the application of the petitioner and the section either rejecting or accepted in report taking the coercive action under section 349 of the Act and both so questioning the amount more than 20% of the demand in question by disregarding the aforesaid first memorandum of the section of direct action which is binding upon him is burden. Considering the suggestion of the parties and the judgments provided upon and executive facts, which appear from the record, that the petitioner has been disposed of by allowing the payment holding of the ensuing action of the second officer under 245 of the Act. making adjustment of the demand of the adjustment of the assessment year 2015-16 in excess of 20% from the refund of the assessment year 2009 without disposing of the objection of the petitioner against the information under section 245 of the Act and taking any formal discussion on the court objection is hard and or not sustainable and include action under section 245 of and taking any discussion on the application of the petition under 226 of the Act and contrary to the appointed office memorandum of the Central Board of Direct Tax for Basic Customs Act is bad and wrong. Accordingly, the assessment office is directed to refund the amount adjusted in excess of 20% of the demand arising out of the assessment order relating to the assessment of 2015-16 from the refundable amount from the assessment from the assessment relating to the assessment of 2009 during 4 weeks from the date of communication of the service. Thereafter, the direction to CIT is also mentioned. It is expected that the appeal in question pending before Commissioner of Income Tax appeal relating to assessment of 15-16 will be disposed of especially without granting any unnecessary adjournment to the now. The second exception is Danieli or also. This is short deflection, your lordship. Considering the fact that just Mr. Sharma, the SSC's objections have not been dealt with anywhere. The objections up to 245. I do not find that. But my lord, can we pay? Page 336, your lordship, and that's the second order. At page 337. And here the table is given, your lordship. I will see my assessment here, demand, etc. Towards the second, the last 3 columns, taxpayer's response not collectible. Well, so the system, if it is not allowing the CPC to look into anything, so that is their system because the power under the Act is only assessing officer. If the CBDT and the department is authorizing the CPC, it is their system. I cannot be penalized for their fault. But it is what is the answer of the assessing officer to this, Mr. Sharma? Why is it happening everything?
I think this matter is way of taking this. The size are not difficult. 150 this is the PPP, the entire thing is taken care of by the city. By the once the size are done by CPC, then only the affecting officer directly are
I mean, there's in fact another case where in case of a non-speaking order passed by the Honorable Bombay High Court in case of Vodafone India, where such a non-speaking order was specifically set aside. But who is the officer who can answer, Mr. Sharma?
we find a CPC can answer.
But if I may, this is only on a pure technical, my not, my what has been my experience in such matters in the past also. But there was one incident, my lord, wherein I had filed a writ petition for another company or same issue. But there, my lord, we were facing the same problem. In fact, the refund order was passed. Still, we were not being given refund. We filed various issues. And in that case, we had to withdraw the writ petition because subsequently the refund was granted to us. What had happened was the assessing officer, he made communications with the CPC. Because the law at all times refers to the assessing officer. So he made communications with the CPC, was able to get a response, and my lord, thereafter, we spoke to the CPC, or what he did, my lord, the refund was credited to us. So my lord, we eventually withdrew the refund.
The assessing officer is respondent number 1.
Yes.
He will not circle 1. He filed the report. Third, Mr. Jhunjhunwala, learned advocate. 31.
My lord.
What has happened?
My lord. GST authorities will issue some point of it. I have submitted reply, my lord. And was suddenly the adjustment order was passed that no reply was submitted. Expiry adjustment order was.
So দেখে দিন তো উপরে করে দেবেন একটু। Give notice to your other side.
Well, I have given notice.
Because if they don't appear again, it will go back to the position where it was.
Lordship, I'm appearing on behalf of the petitioner and praying for an upgradation. My item is appearing in the list of your Lordship under 32.
Yes, what is the urgency?
Lordship, defaulter notice has been issued by the customs office. Lordship, some urgency need to be
Give notice to the other side.
No, Lordship, I have served notice.
Serving, no, service of upgradation.
Yes, Lordship.
Because it is appearing at 31, suddenly it comes up at the top. If you are not there, I will not take. I'm making.
Lordship, I will serve it.
I'll upgrade it, but if they don't come, I will not take it. Next, call for only.
My lord, I appear for the. I'm being led by the officer. My lord, we have come. He will.
Yeah, Lordship, before I'm coming to the subjective question, what is first brief out the brief history of the case. Lordship, the petitioner case for the assessment year 2018-19 was selected for the estimate. And the assessment was completed under section 43 on your Lordship 11/09/2021. And the demand was raised more than 2.7 crore, 70 crore, your Lordship. Thereafter, your Lordship, the petitioner agreed and a file before the Commissioner appealed on 29th September 2021, your Lordship. Thereafter, your Lordship, the petitioner did not pay the demand amount within the stipulated time, and even, your Lordship, not file a stay of demand petition before the authority. Therefore, the petitioner was treated as an assessee in default as per the provision of section 220 subsection 4. Your Lordship, I'm coming to the particular section only. For the assessment year 2021-22, the intimation under section 143(1) dated 25th October 2022. And on the same day, the intimation 245 was issued and served to the assessor. The refund is processed to be adjusted against the outstanding demand and the requested for response. But the petitioner has not filed any response. Thereafter, the refund was adjusted against the outstanding demand. For the assessment of 2022-23, same happened, your Lordship. Now, your Lordship, I wish to draw your kind attention, your Lordship, here. Notice under section 260, dated 13th March 2024, your Lordship, issued and direction can file a written submission in the ground of appeal, your Lordship. But, your Lordship, the petitioner requested for the adjournment. Subsequently, your Lordship.
Further, your Lord, those are part of the record.
Yes, your Lord.
Show me that.
That is the page number 6, your Lordship.
Page 6
of the red.
Yes.
Para 8.
Yes.
That is the. after the filing of the state appeal before the respondent number 5, a notice dated March 13, 2024 was issued under section 250 of the Act by the respondent number 5, by which your petitioner was directed to file a written submission in the support of the ground of appeal on or before 28 March 2024. But unfortunately, the employee who deals with the income tax matter was leave during the said period, and your petitioner did not able to file written submission. Your petitioner thereafter also received 2 hearing notices dated December 2024 and October 2024, your lordship, put by the respondent number 5 under section 250, and your petitioner in this response the said notice out extension for the time limit. Now, your lordship, I am coming to the circular 1914. Page 91. Para number 6, your lordship. Guidelines for staying demand. A demand will be stayed only if there are a valid reason for doing so. Merely filing an appeal against the assessment order will not be sufficient reason to stay the recovery of demand. There is a few illustration, your lordship. Now, your lordship, kindly come to the it is clarified that these situations also stay may be granted only in respect of the amount attributable to such dispute points. Further, where the subsequent found that the SSC has not cooperated in the earlier disposal of appeal. So here this case, Commissioner Appeal has issued 3 notices in 2024. Now, here each and was fighting. They have not submitted any written submissions for the commissioner. Now, your lordship, your lordship, I am coming to the section 220, subsection 4.
Even till date, you have not filed written submission in the appeal.
That instruction I have to take, but the based on my, you know, you can take that paragraph, you know, you find thereafter no further notice will issue from the end of the slide.
Yeah, but you got 3 opportunities.
Whatever is there on the record is there. I will not making submission to that.
If it is not filed, I don't think so now portal will also be open to file on me at the time we will welcome.
Oh, I'm sorry. My understanding is correct. Suppose my lord, the portal open for filing of written submission for a specified date. My lord, these talk for 3 adjournments as rightly pointed out from my awareness, but we have placed on the fact and record. So if any further giving attempt is further to be made on the part of the associate to file written submission, then a further notice should come and then only we can move on by the filing written submission. That there is the the written submission should be submitted. In any way, my lord, this CIT does not proceed with that. I think there is no.
Yes, probably.
No, that's a different thing, but CIT has not done.
Not filed.
Now, your lordship, coming to the section 220, section 4. If the amount is not paid within the time limit under subsection 1 or extended under subsection 3, as the case may be, at the place and to the person mentioned in the said notice, the SSC shall be deemed to be defaulted. Now, your lordship, kindly come to the section 220, subsection 1. Any amount other than by way of advance tax is specified as a payable in a notice of the demand under section 156 shall be paid within the 30 days of the service of the notice at the place and to the person mentioned in the notice. Now, your lordship, I will rely upon the one Supreme Court judgment on this particular issue. Your Lordship, this is the 2001 116 tax and 63 Supreme Court, Your Lordship. The Mohanbale versus Commissioner of Income. Your Lordship, kindly come to the para number 11, Your Lordship. The ratio should be applied in this.
Paragraph 11.
11.
Yes.
Section 156 provides as under notice of demand when any tax, interest, penalty, fine, or any other sum is payable in consequences of any order passed. Under this section, the assessing officer shall serve upon the assessee a notice of demand in prescribed form specifies the sum so payable. If the amount specified in the notice of the demand under section 156 is not paid within the time limit by the subsection 1 or extended subsection 3 of section 220, then the assessee shall be deemed to be default under subsection 4 of section 220 alone. The tax recovery certificate can be issued under section 220 when and the assessee is default or is deemed to be default. Proceedings for recovery of the tax under second schedule can be initiated against a default. Now, Your Lordship, I am coming to the section. Your Lordship, section 245 is a wider.
Yes.
Your Lordship, section 245, not even say to address outstanding demand. It is also empowered to hold the refund on ongoing assessment or reassessment proceedings. So now section 245(1), where under any of the provision of this act, a refund becomes due or is found to be due to any person, the assessing officer or a commissioner of principal commissioner or chief commissioner or principal chief commissioner, as the case may be, in the lieu of the payment of the refund, set off the amount to be refunded or any part of that amount against the sums, if any, remaining payable under this act by the person to whom the refund is due after intimation. After giving an intimation in writing a lot, in this case, already intimation served to such person of the actions proposed to be taken under this subsection. Now, you also kindly come to the section 345(2). There is an empowered to hold the refund where a part of the refund is set up under the provision of subsection 1 or where no such amount is set up and refund becomes due to the person and the assessing officer having a regard to fact that the proceeding for the assessment or reassessment are pending. In a case of such person, he may for reasons to be recorded in writing and with the previous approval of the principal commissioner or commissioner as the case may be, without hold the refund up 60 days from the date of which such assessment or reassessment is made. Earlier, I was relying upon the one Supreme Court judgment, Northern Cold. Now, Your Lordship, I am coming to that particular judgment.
Yes.
Your Lordship, para number 4. In respect of the assessment of 2013, assessing officer has passed an order of stay of demand for a period of 6 months. Whereas the order of refund has been passed in the period of stay. Therefore, the refund amount will be adjusted against the demand for the assessment year 2013-14. Such demand was stay, the order of stay of the assessing officer is as under. Your Lordship, in this stay order, Your Lordship, the circular 29 February 2016 was
Referred
completed. And Your Lordship, the case, the Commissioner of Appeal case is pending before the appellate forum. Your Lordship. Now, Your Lordship, I am coming to the para number 8. We have heard learned counsel of the parties and find no merit in the present petition in respect of an argument that the demand for the assessment year 2013-14 was stayed by the assessing officer in exercise of the power confirmed under section 220 subsection 1 of the act. We do not find any merit. A perusal of the order of the stay passed by the assessing officer on 12th September 2016 in the terms of section 220 subsection 6 of the act shows that the even in the said order, an amount of so and so has been adjusted. After adjustment, the balance amount was stayed for the period of 6 months or up to the decision of the first appeal, whichever is earlier. After passing of such order, the assessment for the assessment year 2014 was finalized on such date. The order under section 220, subsection 6 of the Act, as well as the intimation under section 245 of the Act was issued by the same assessing officer. Therefore, the argument of the learned counsel for the petition that the assessing officer should have modified its order before the order of adjustment is not tenable, as the order of the stay was not passed by the any other superior authority by the assessing officer himself. The Honorable Supreme Court in the Sri Chamundi Moped Limited, Church of the South India Press Association, Madras, AIR, 1992, Supreme Court 1439, has examined an effect of an interim order of stay. The Supreme Court held that distinction has been made between the questing of an order and stay of an order. Questing of order result in restoration of the position as stood on the date of the passing of the order which has been quelled, but the stay of operation of the order does not, however, lead to be such a result. In a view, therefore, thereof, the order of the assessing officer not to be recovered, the demand for the assessment here does not lead to setting aside the demand itself. The said demand could very well be adjusted against the refund due for the previous year 2012-13. The para number 9. Similarly, the assessment was completed for the assessment of 2014-15. On such day, the demand for the recovery of the tax due was issued on such day, giving time to the assessor to deposit the tax due within the 30 days. Such demand notice is for recovery of the amount which is payable within the 30 days and after 30 days. The consequences as contemplated under section 156 of the Act follows, but the assessment have been finalized on such date. The assessment officer should adjust the amount against the refund payable as it was amount due and payable by the assessee. Thus, it had 30 days time to deposit the same year lot. The para number 11. Para 11 yellow.
11.
Fifth line yellow. Section 245 of the Act, in fact, permits the revenue to set up any demand from the amount to be refunded, but the only condition of intimation in writing to such persons against whom action is supposed to be taken. We find that the demand has been raised against the petitioner for the assessment at 1314 and 1415, and intimation having been sent to the petitioner on 5th January 2017. The amendment of the section 245 of the Act was satisfied by the revenue before making the adjustment from the refund due to the assessee from the tax due to the assessee for the subsequent year. Your Lordship, this judgment was challenged before the Honorable Supreme Court, and the Supreme Court dismissed the assertion. But Your Lordship, with the reason, the Supreme Court dismissed the assertion with the reason. In fact of this case, we are not inclined to interfere with the order of the High Court. However, after the adjustment of the tax in the next year, the balance amount, if any, should be refunded to the petitioner by the income tax department, exception with petitioner. Lordship, this is a special law. The reason is that the court would be exact applicability of the Article 141. So this judgment, Your Lordship, kindly consider. Now, Your Lordship, I am coming to user manual of the instrument. Response to outstanding demand user manual. Page number 11. On response to outstanding amount paid, select disagree with the demand either in full or in part. Option clicks add reason. There is a format here. To select the reason for this agreement, select for the option and click apply here. Now you have to the next page 12. There is the reason. Demand paid by the salon has been without open salon detail. This very much. Demand paid and the salon has changed with the open salon detail. Demand paid and the salon has no change. Demand already reduced by rectification, revision, application, appeal order, Your Lordship. Demand already reduced by the appellate order, but the appeal effect to be given. Appeal has been filed, step petition filed, Your Lordship. Step petition filed, Your Lordship. That is the 6th number point, Your Lordship. Appeal has been filed, stay granted. Appeal has been filed, installment granted. Therefore, revision return filed at CPCO. So there is the reason, Your Lordship. If you are disagree with the demand, you should apply to that reason. But in this case, the petitioner has not responded to this outstanding demand. Now, Your Lordship, my learner senior friend has to rely upon the form and the statement. So I have to distinguish of the same. Your Lordship, first I will come to the Rajendra Kumar versus the Assistant Commissioner of Income Tax and Other. That is the Rajasthan High Court. Your Lordship, para number 7. And if
Yes.
The case on the hand, classic example of the power usage was quite strong. Appeal in the section of the since the order dated December 30, 2019, without waiting for the 30 days to decide. He filed the appeal on a merit prescribed format on December 26, 2019. It is a fact of the records which is admitted by the respondents themselves that till date, the Commissioner of Income Tax Appeal, for the reason best known to him, has not considered the said appeal, which is beyond control of the petitioner. So, Your Lordship, in this case, the fact is different. In present case, Your Lordship, the Commissioner appeal has notices to the petitioner to file a return. Petitioner has sought on time. They have not cooperated with the assessment process, sorry, appeal process. So this is the victim, this is the package. I allowed to the subsequently this Supreme Court order was challenged. This Rajasthan High Court was challenged before the Supreme Court. In this Supreme Court, a lot of the conclusion was this. There is no reasoning order as by the Honorable Supreme Court.
Yes. Yes. Which judgment are you saying?
The Supreme Court. Assistant Commissioner of Income Tax.
Rajendra Kumar.
There is a simply a confused judgment. There was without the reasoning with the experts. Now you got it. Verified India Limited. Para number 10.
There are 10.
Considering the submission of the party and the judgment relies upon the adjudicate facts, it appears on the record that this which speaker is disposed of by allowing the same, by holding that the impugning action of the assessing officer under section 245 of the Income Tax Act 1961, making adjustment of the demand of the assessment year, which is in excess of 20% from the refund of the assessment year 2008-9. Without disposing of the objection of the petitioner against the intimation under section 245 of the Act. Without disposing of the intimation yellow. Objection filed by the SSC. But in present case, your lordship, the petitioner has not filed any objection before the authorities. Your lordship, I am coming to the our court Daniel India Limited, your lordship.
Yes.
Lordship,
Yes.
Your lordship, there is the commissioner appeal are pending, your lordship. But in present case, your lordship, the commissioner appeal is pending. But due to petitioner not responded, so therefore this case is distinct. Now, your lordship, I am coming to the Bombay High Court of Goa, your lordship.
Bombay.
Similar issue, your lordship, that
Which one?
Bombay High Court
Bombay.
and you telecommunication.
Andrew, yes.
Your lordship, in this case, your lordship, the CIT appeal proceeding is not cooperated by the petitioner, your lordship. There is the para number 4, your lordship. Para number 8 first.
Yes.
We have carefully considered the revealed circumstances and the submission made by the impugn demand of rupees so and so, and the petitioner has challenged the said demand in an appeal which is pending before the commissioner appeal. According to the response, the impugned order refusing to grant stay is passed on the administrative side. Be that as it may, OM dated 29 February 2016 to the extent of the relevant period thus. In order to streamline the process of the grant of the stay and the standardize the quantum of the lump sum payments required to be made by the SSC as the condition for the stay of the demand disputed before the Commissioner appeal, the following modification guidelines are the issued in partial modification of the instruction number 1914. That is the mother circular below. In a case where the outstanding demand is disputed before the Commissioner appeal, the assessing officer shall grant stay of the demand to the disposal of the first appeal on payment of the 15% of the disputed demand unless the case falls in the category discussed in paragraph B. Thereafter, you'll have to B, E, D, E, you'll have to. In granting stay, the assessing officer may impose a such condition as he may think it. He may enter earlier. Required an undertaking from the SSC that he will be cooperated in the earlier disposal of appeal, following which the stay order will be cancelled. In the present matter, so your lordship, there is no stay in the present matter, your lordship. Reserve the right to review the order passing after the expiry of reasonable period of the 6 months, or if the SSC has not cooperated in the earlier disposal of the appeal, or where a subsequent pronouncement by the higher appellate authority or the court alters the above situation. Your lordship. Now, your lordship, coming to the Supreme Court judgment, Dana Begum, which was relied upon by here. Yes. Your lordship, in this case, the rule of harmonious construction will not apply when there are no conflict provision. Your lordship. This case is applied. But your lordship, in here, there is no conflict in your lordship in the provision. Now, section 224 says SSC deemed to be default. If he not paid within the stipulated time, not filed stay petition, even not completed of the Commissioner appeal, there is a clear section, your lordship, section 2, subsection 4. Now, your lordship, I'm coming to the instruction number 12 of 2013, your lordship. It was relied upon. Yes. Para number 5. In view of above direction of the Honorable High Court, I am directing to convey the provision of the Section 245 of the IT Act is to take adherence of to before making any adjustment of refund in respect of the adjustment of the refund payable by the CPC at Bangalore. The procedure details in para number 2 above, your lordship. Now, your lordship, I am coming to the para number 2. The Honorable High Court in this context had issued interim direction via its order dated 13th August 2012 as under. We issue the interim direction to the respondents that they shall in further follow the procedures prescribed under section 245 before making any adjustment or refund payable by the CPC at Bangalore. The SSC must give an opportunity to file a response or reply, and the reply will be considered and examined by the assessing officer before any direction for the adjustment is made. The process of issue of prior intimation and service thereof on the SSC will, as per the law, the SSC will be entitled to file their response. Response before the assessing officer mentioned in the prior intimation, your lordship, means prior to the notice, prior intimation 245, your lordship. Since, your lordship, what happened in this case? 143(1) issued. 143(1) was issued, your lordship, wherein there is a note, your lordship. This refund will be adjusted against your outstanding refund. So in this case, you should file intimate, that is file their response here also. But I'm coming to the 141.
Page.
Your Lordship, this is not a part of the rate here. Because your Lordship, they have not filed a 143. Lordship, it is the page number. Well, page.
Page 12.
143, one for each year. 22. 22, 20. 20 years.
Yes.
Your Lordship, there is a note. If any correction of the tax, less sorry, Your Lordship. This is-
2 pages thereafter.
Yes, yes.
Got it.
The refund determined in this estimation along with the interest under section 244A is subject to adjustment of outstanding demand. If any under section 245(1) and without holding of the balance refund, if any, as per the provision of section 245(2), if applicable. Your Lordship. So therefore, Your Lordship, in this intimation, there is a note, Your Lordship. So in this note, the petitioner should respond there as per the user manual, Your Lordship.
Yes.
Now, Your Lordship, this is my last slide. Your Lordship. Your Lordship, this rate, Your Lordship, filed after almost 3 years or 2 years, the cause of action. The cause of action in the year 2022 and 23, Your Lordship. And the writ petition was filed, Your Lordship, 2023.
Yes.
Yes. Kindly consider the honorable side. You see the rate. When was that?
When was the appeal filed? My lordship will take paragraph 8 of my writ petition. Much has been submitted on basis of paragraph 8. Just for clearing the doubt, written submissions have been filed thereafter. Written submissions have been filed on 10/11/25. That is my instruction from the instructing the consultant, right? Now, will kindly take paragraph 8. Your petitioner states that it has filed the appeal before. The respondent number 5 on September 22, 2021. Well, that goes without saying. There is no doubt about it. So, my lord, whatever appropriation has been made prior to, my lord, issuance of notice for filing return submission at the appropriation first was made for 1 year in 2022, for another year in 2023. For the year 2023, when the main appropriation was made, notice was issued on, say, day 1. We were given 21 days to respond to the notice. I am grateful to my learned friend for showing that DRN, that module which has been provided. Notice was given on, say, 10th of November, correct? 10th of November 2023. And, my lord, on 11th of November 2023, appropriation adjustment was made. And, my lord, we were required to give our response to the DRN as per the module within 21 days. So, whatever appropriation has been made, it is not my inaction in not getting the appeal disposed of which has actuated the adjustment. Adjustment was made much prior to the notices for making written submissions. Admittedly, only in 2024, am I correct or wrong? Tell me. Only in 2024, kindly take my paragraph 8. Indisputably, these are the paragraphs. The revenue is not questioning my averment. But unfortunately, may I just take your lordship? So, appropriation was made in 2022 and 2023. After filing the said appeal before respond number 5, a notice dated March 2013 was issued under section 250 of the Act by the respond number 5, Badjao, by which your petitioner was directed to file written submission in support of the grounds of appeal on or before March 28, 2024. That is after 3 years from the date of preparing appeal. But unfortunately, the employee who dealt with the income tax matter was on leave during the said period, and your petitioner did not able, it should have been was not able, to file its written submissions. Your petitioner thereafter also received 2 hearing notices on so and so date, which are also in 2024, one on September 7, 2024 and October 3, 2024 by respond number 5, and your petitioner in response to the said notices sought extension of time. But today, my learned friend has made an attempt, obviously on the instruction given by his client, that this particular action of adjusting the refund against the dues payable in terms of the assessment orders has been actuated by inertia on my part to proceed with the appeal. That is not the case. The dates would show that, indisputably. Secondly, my lord, now the written submissions have been filed. So appeal will take its own course, appeal will be decided on its own merits. I'm not on that, because I have not questioned the merits or demerits of my assessment order. Now, my lord, straight away, I take your lordship once again back to this paragraph. My learned friend says that adequate opportunity was given. Sorry, just one. Kindly take paragraph 12. First, my lord, may I take your lordship ने 2022 वाला दिखाओ पहले. My lord, in 2022, the first adjustment was made. That would be evident. Yes, claim the refund. The said refund was, your petitioner, kindly take paragraph 12. Your petitioner was surprised to receive a purported notice dated November 10, 2023. That is much prior to the notices issued by the appellate authority. Issued under section 245 of the Act, by which it was proposed to adjust the said refund against the outstanding demand of rupees 37,740 for the AY. Are bad ja. They are so charged up, my lord. They can't sit. For the assessment year 2016-2017 and 2 crore 63 lakhs 64,130 for the assessment year 2018-2019. In the said notice, it was stated that if your petitioner did not take any action within 21 days from the date of receipt of the said notice dated November 10, 2023, Outstanding demand as on that date would be considered for adjustment against the refund as determined by the said intimation dated September 20, 2024. Your petition states that even though the said notice dated November 10, 2023 granted 21 days for response by a petitioner, the response number 2, however, by a communication dated November 11, 2023 adjusted the entire amount of rupees 1 crore 64 lakhs 3,820 against the demand for the AY 2018-2019. So, my lord, the circular and my lord, the directions contained in the circular, my lord, were not adhered to. My lord, the authorities admittedly, my lord, indisputably, I will not use the word admittedly, indisputably acted in contravention of the directions contained in the circular, so far as 245 is concerned. Now, my lord, I come to this innovative argument of section 220 subsection 4. Then I will come to the other part. Give me the book. Yes. 220 subsection 4, if your lordship kindly takes. Yes. If the amount, my lord has got the book. I'm sorry, my lord. I should have waited.
The 20 subsection 4.
4.
Yes.
If the amount is not paid within the time limited, I'm sorry, under subsection 1 or subsection 3, my lord, that is first, my lord, the 30 days, and then, my lord, an extension for whatever period the assessing officer may think fit and proper. As the case may be, at the place and to the person mentioned in the said notice, the assessee shall be deemed to be in default. Similar, subsection 4 has to be read along with subsection 6, where a specific provision has been made. What happens when the assessee has challenged the order and preferred an appeal under section 246A? Well, the assessing officer, where an assessee has presented an appeal under section 246, the assessing or 246A, the assessing officer may in his discretion and subject to such conditions as he may think fit to impose in the circumstances of the case, treat the assessee as not being in default in respect of the amount in dispute in the appeal, even though the time for payment has expired, as long as such appeal remains undisposed. I mean, subsection 6 is an exception to subsection 4. Now, may I use the expression, though it is a standalone subsection, it really acts as a proviso to subsection 4, because it carves out the exceptional circumstances under which an assessee cannot be deemed to be an assessee in default.
But Mr. Mojumdar, subsection 6 of section 220
right
does not say that merely by filing an appeal you will.
No, not at all, not at all. No.
Discretion still lies
They
with
are
the assessing officer.
Absolutely. I bow down.
He may not treat. He may not
treat or may treat, but
treat
this
him
is
as
an
a
exceptional circumstance carved out, where, my lord, the assessing officer whereby the assessing officer is vested with the discretionary power as to treat or not to
the
treat.
question will be whether in a circumstance or in a given circumstance where the assessing officer has decided not to treat you in default, whether he has rightly or wrongly exercised the discretion that is vested.
My submission is slightly different. My submission is that this statutory discretion was being used, abused, or not used. Malad, we go back to this old the theory of Lamarckian theory, use or disuse. So it may be use or disuse of that particular provision. That is why circular number 1914 was issued, that you please exercise your discretion appropriately and get the money recovered from the defaulting assessee. That's the sum and substance of 1914. Then, my lord, in 2016, my lord, the CBDT came up with this new circular, where they say that you exercise your discretion, but it is like
the guidance for
the discretion.
Guidance for the
discretion. It is like defining the discretion that you will always, what you will do, at the point of time 15%, let me take X percent, you will always recover X percentage from the assessee and not treat him as an assessee in default.
So to such extent, Rajasthan High Court would not be agreed, saying that merely by filing an appeal, he will be treated as an assessee in default.
Well, it will
He
be,
still has the discretion.
Discretion, but
The
it
correct
is
way
limited.
would be that the assessing officer may exercise discretion to treat or not to treat the assessee in default upon the filing of an appeal. If he does not file an appeal, then he will always be treated as an assessee in default.
Always.
But if he files an appeal, then the question of exercise of discretion
Well,
comes,
that
which again is to be
absolutely,
exercised in
absolutely,
terms
I
of
bow
the
down to your
circular.
lordship. Well, my submission would be, well, subject to whatever your lordship would finally consider, is that when an appeal is filed, my lord, a discretionary power is vested in the assessing officer, no doubt about it. He may decide, he may not decide that no, he's still an assessee in default. But this discretionary power has now been, my lord, somewhat defined. To what extent, my lord? You take 15%. When you take 15%, you cannot treat the assessee in default. That's the clear instruction from the CBD. If you take less than 15%, if you decide to take less than 15%, you must report it to the superior officer for his approval. If you decide to take more than 15%, then also you have to refer to the superior officer. So this is the sum and substance. But in this case, when they appropriated that amount in excess of 20%, because 2017 circular enhanced that limit to 20% instead of 15%. But there was no reference made by the assessing officer that I am going to realize something more than 20%. That there is no reference in terms of the circular dated circular 2016, which was amended by the circular of 2017 so far as the percentage is concerned. But the modicum, everything has been laid down in circular of 2016. If your lordship kindly comes back to circular of 2016, then I will deal with his judgment. My learned friend has cited authorities. Kindly take circular number of 2016, page 94. Yes.
Yes.
Kindly take, my lord, 4 capital A, because we are not covered by 4 capital B right now.
Yes.
My lord, kindly take, in a case where the outstanding demand is disputed before CITA, my lord, disputed obviously mean preference of appeal. The assessing officer shall grant stay of demand till disposal of the first appeal on payment of 15% of the disputed demand, unless the case falls in category discussed in para capital B hereunder. Now, para capital B, my lord, then, my lord, your lordship will find that clause B, small b. Small b says, it's a deletion. Para B is not at all applicable. That is not my case even. That is nobody's case. Then, my lord, now para 4E, in granting stay, the assessing officer may impose such conditions as he may think fit. He may inter alia, kindly come to III, reserve the right to adjust refunds arising, if any, against the demand to the extent of the amount required for granting stay and subject to the provisions of section 245. So, my lord, this is how, my lord, the power under exercisable under section 245, my lord, has been, my lord, somewhat limited, while when somebody exercises power under section 220 subsection 6. So, my lord, whenever an appeal is pending, but 245, I made these submissions in my opening submissions, that there may be 2 scenarios. No appeal, there is an appeal. No appeal, everything can be taken away. But when there is an appeal, 245 must be read in the light of 220 subsection 6 and the circulars issued by CBDT, and, my lord, the realization would be to the extent of 20%.
Unless the situation,
obviously, my lord, unless, my lord, the assessing officer feels that no, I will charge 50%, 80%, that may so happen. That happens only with the approval of the superior authority, not otherwise. Now, my lord, I come directly to the judgment cited by my learned friend. Kindly take, my lord, what is the judgment about? Lordship will, my lord, this is the judgment cited. This is, yes, 248 ITR 799, Mohan Wahi.
Yes.
This is not at all relatable to a situation or circumstance under section 220 subsection 6, where section 245 of the Act. The judgment, well, we have been taught from day one, is an authority for which, for what that it actually decides,
and not what logically
what
follows.
deduces therefrom. And what was decided, my lord? It was decided that precondition for invoking powers under section 245 would be issuance of a notice under section 156. In the absence of a notice under section 156, there cannot be any recovery proceedings at all. Kindly take paragraph 16. We are therefore, these are certificate proceedings at the end of the day. We are therefore clearly of the opinion that service of notice of demand on the assessee under section 156 is mandatory before taking steps for recovery under second schedule. But this is the sum and substance of the judgment. This is not at all relatable to 220 subsection 6 or 245. Non-service of notice of demand goes to the root of the validity of the subsequent proceedings for recovery. A sale held in recovery proceedings initiated without serving the notice of demand shall be invalid and shall be liable to be annulled on being called in question. There was no appeal in this case at all. Kindly take, my lord, paragraph 18.
Yes.
In the present case, the plea as to non-service of demand notice have been raised before the High Court in our opinion. The High Court should not have adopted too technical an approach by refusing to deal with the plea because it was not raised in the manner in which the High Court thought it should have been raised. The plea went to the root of the matter. The plea was raised before the departmental authorities right up from the RTO to tribunal, and that was not given up before the High Court also. It would have been difficult for the High Court to ask the Income Tax Department to, it would not have been difficult, it would not have been difficult for the High Court to ask the Income Tax Department to produce record of the proceedings and to show if the demand notice was at all served on the assessee. A little more sensitive approach is required to be adopted in the process of dispensing justice when it is found that valuable property of a person was sought to be sold away for recovery of such areas as it did not exist at all. Thus, on both grounds, we hold that the sale of suit property in favor of respondent number 3 is liable to be set aside, appeal is allowed, the impugned judgment is set aside, writ petition filed or stand allowed. But this is the sum and substance of this judgment. This judgment, my lord, is not the authority for the proposition which I am trying to canvass before your lordship and which my learned friend is trying to distinguish before your lordship. That this proposition is otherwise not a tenable proposition. Now, my lord, now coming back to this, lordship, my learned friend referred to user manual. I am grateful to my learned friend. My lord, your lordship will find paragraph page 11 has been referred to. If your lordship kindly compares page 11 with page 161 of our petition. ठीक है मेरे पास. Yes, madam. Before any adjust, this is volume 2. Because this is where I will demonstrate with your lordship how this
161.
Yes, 161.
Yes.
But this is the notice which we got from the CPC regarding adjustment of refund against outstanding demands. Kindly take, my lord, it is somewhat akin to this because this is the procedure the department adopted in my case. So, my lord, I will go by my case. My lord, kindly may I take your lordship? Status proposal to adjust refund determined. My lord has got that?
Yes.
Then date of communication, it is 10th November. My lord has got that?
Yes.
Then resolve by how? Agree or disagree with the outstanding demand, which is somewhat, my lord, akin to, my lord, page 11, response from assessee, demand is correct, disagree with demand. Somewhat like that. Then, my lord, kindly take, this is the path which is given, the link which is given. Then in the
Yeah,
next,
if you click the link, after you click this response to outstanding demand, you will go to the page which has been shown by
yes.
Mr. Jaswant.
Now, my
That
lord,
is what the page is.
right, it may be so, my lord, I will stand correct. So if we go to that, yes.
Yes, that is the heading.
That is the
Response to outstanding demand is
Yes,
the heading,
Yes,
which
absolutely
is
right. Absolutely.
the tail of the path.
Yeah, absolutely right, my lord.
You
Kindly
click
take-
that, you go to this page, and thereafter
Yes.
the page is to be.
Page will, the page will open up. Now, my lord, kindly come to page 162. This is the most relevant page so far as this adjustment is concerned. Your lordship will find there are two assessment years involved, as indicated at page 162. AY 2016, which would mean 2016-2017, AY 2018, which would mean 2018-2019, and Miller, this is the amount involved. Not collectible, no response, no response. AO's response, no response. Now, Miller, kindly come, procedure for filing an online response is given at the bottom. Then, Miller, the outstanding demand as on date will be considered for adjustment against your refund if you do not take any action within 21 days from the date of this communication. What happens, my lord, is that at page 164, your lordship will find on the very next day, that is on 11/11/2023, my lord, the adjustment was made. Within next day, the following day. These facts can never be disputed by the department. So two facts can never be disputed by the department. First, my lord, no opportunity was given as provided for in the notice itself. Circular has been violated, the provisions contained in the circular. Secondly, my lord, my inaction in proceeding with the appeal has no correlation with the adjustment because this was done much earlier. This has no correlation. My appeal could have been dismissed, my appeal could have made a different fate, that's a different thing. But the adjustments were made, at least, my lord, 7 or 8 months prior to March. So 4 months prior to the adjustments were made, 4 or 5 months. So these are not relatable. So, my lord, now I come to the interpretation given by my learned friend so far as, my lord, the judgment of which High Court, MP High Court,
yes,
which has been affirmed by Supreme Court, and whether it become a law declared by Supreme Court under Article 141. दिखा एक मिनट, मेरे पास भी होना चाहिए. हाँ, नॉर्दर्न कोलफील्ड्स है ना.
Northern Coalfields.
Well, I am grateful to my learned friend for supplying much emphasis to this order passed by the Supreme Court, which goes to, my lord, aid me in my submissions that this is restricted to the facts of that case. Because it begins with the sentence, with the phrase, in the facts of the case, we are not inclined to interfere with the order of the High Court. However, after adjustment of the tax in the next year, the balance amount, if any, should be refunded to the petitioner by the Income Tax Department. Specially, petition is dismissed. Now, my lord, I will take your lordship back to, so Rajasthan High Court. So that distinction which has been sought to be drawn by my learned friend is not available. So Rajasthan High Court remains, my lord, an authority which I beseech your lordship will consider, your lordship will take the final call. And at the end of the judgment of rendered by Rajasthan High Court, it is not only the principal amount, the lordship will find from there, the interest is also made payable by the department. And thereafter costs were imposed, which were, my lord, in the Supreme Court, that costs were, my lord, waived. That part of the judgment has gone. So, my lord, now, so, my lord, these are my respectful submissions. Now it is up to your lordship and lordship's work start.
I'll keep it one more day. So many judgments are there. I'll go through the papers.
Yes, my lord.
When can you,
Sorry, madam.
when can both of you be available? Next week?
Your lordship will deliver the judgment or any?
No, I'll keep it one more day, then I shall deliver.
Very well, my lord. My lord, then Monday नहीं होगा. My lord, your lordship takes up the revenue matters on
Every
Monday?
day. Every day, every day.
Oh, original side.
Excepting Friday.
But Thursday, my lord.
Thursday we can. Uh,
Number 2.
Excellent. Yes.
My lord, item number 2 and 3, my lord, similar matters arising out of same adjudication order. My lord, on last occasion, Mr. Chakraborty was arguing item number 2. My lord, I was informed by my learned friend.
Who is appearing for the respondent?
My lord, I was informed by one of the juniors of Mr. Kundolia that he will be seeking for some time today.
Making it not today.
My lord, then day after tomorrow, my lord.
Porsu din kore din. Day after tomorrow.
Your Lordship. If I may recapitulate, Your Lordship, we had challenged the.
Your other side, who is there?
If the Samuel was addressing to that matter where penalty was imposed.
Let
he
us
did
see
not-
both sides are there because there is no use. We will not be able to move effectively.
He was.
Passing it over. Next.
Hello, I don't know if I am praying for not today one.
Not today. Next.
Item number 6 and 7, I'm seeking a short accommodation, Your Lordship.
6, 7. 6, 7 দুটোই not today করে দিন.
It can be 6 for Wednesday, for Thursday.
Making it not today. 6, 7 both not. Very well. Next.
8 and for the petitioner, my lord.
Kundalia is appearing, my lord. He's on legs before court 1, my lord. Can it be?
Not today. What is the matter?
My lord, this matter your lordship has heard substantially.
That is irrelevant. What is the matter?
This matter, my lord, I was challenging the action of the customs authority in not releasing a quantum of gold and in not refunding me the amount that has been accrued to me subsequent to the passing of the order by the tribunal that I am entitled to claim the gold.
And what is their defense?
They, my lord, have sought for their they have sought for instructions on previous occasions, my lord. 3-4 occasions they have sought for instructions, my lord.
Very well. Let us see. Not today. Next.
My lord, kindly keep the matter day after tomorrow, my lord.
আচ্ছা 9-8টা day after tomorrow করে দিন.
One more indulgence, my lord. Item 3 and 4, my lord. Mr. Kundalia is appearing.
3 and 4, no, 2 and
2 and 3.
Yes, day after tomorrow.
Item number 9.
Other side?
But the other side, Mr. Dodoria, just one point on this is a matter wherein my lord asked me to file a supplementary affidavit. Actually, this is a matter wherein my lord reassessment proceedings were initiated after the assessee company. My lord had CIRP proceedings have been initiated.
Oh.
So my lord,
The orders were not there on record.
So my lord, when this was the supplementary affidavit, I understood my item is not there. I served a copy of it.
Mr. Jhunjhunwala. two affidavits, it won't look good.
My lord.
Not good.
My lord, I am appearing virtually, my lord. May I be allowed to appear virtually, my lord, in this case? Am I audible, my lord?
Yes, yes. 10 is called on.
My lord, item number 10, I am appearing, my lord.
Yes.
In item number 10, I am appearing. Yes. What happened, my lord? This is the case of double PAN. My lord, petitioner is a company registered under the Companies Act, my lord, and the registration of certificate of incorporation was issued by the ROC Hyderabad, my lord. Your lordship will find at page 25, my lord. Kindly come to page 25 of my writ petition, my lord.
Page 25.
Yes, I have registered office in Hyderabad, Telangana, my lord, and the certificate of incorporation was issued by the in the state of Telangana, my lord.
Yes.
In the state of Telangana.
Yes.
Now, my lord, I made an application for, my lord, the issuance of the PAN card, and my lord, the PAN card authority, my lord, is also from the Andhra Pradesh, my lord. Your lordship will find page 27. PAN card has been issued, my lord, from by the authority, my lord, situated in the state of Andhra Pradesh. Now, my lord, kindly see.
Yes.
My personal details, my lord, as appearing from the page 28 onwards, my lord. That my registered office was, my lord, declared as in Hyderabad. No additional place of business or, my lord, the branch office or, my lord, the other godown or warehouse was declared in anywhere, my lord. Now, my lord, what happened? We started filing the central excise return, my lord, on the basis of the registration number issued to us, my lord. Your lordship will find page 30 onwards the registration, the central excise registration. Now, based on this central excise registration number, my lord, when the GST law came into force, before that provisional registration was granted to us, my lord, GST registration. That your lordship will find at page, my lord, 34. Page 34.
34.
Yes. My lord, your application for enrollment of existing taxpayer in Telangana is submitted successfully against such and such. Your provisional ID is 36 AAA CE 5961 F1 ZP. Now, my lord, I was filing the returns from Telangana only. My lord, there was no place of business in the state of West Bengal or anywhere, my lord. Now, my lord, suddenly we came to know that GST registration is PAN-based GST registration, my lord. When we tried to link with my PAN number with the GST registration, there was a failure. Therefore, my lord, we surrendered this GST registration and obtained new registration certificate. My lord, your lordship will find page 35. This new GST registration was given to us based on our PAN number, which has been issued by the state of Andhra Pradesh, my lord. Your lordship will find page 35. GST came into force, my lord, from 1st July 2017. And we, my lord, this new registration certificate was issued on 25th August 2020.
Yes.
My lord, there your lordship will find this additional place of business is also in Telangana at page 36.
Yes.
Now thereafter, my lord, this is about the GST registration. And the order of cancellation of the earlier registration is your lordship will find page 38.
Why are you agreed now, Mr. Dugar?
Now, my lord, what happened? The authority, my lord, from the state of West Bengal Income Tax Authority issued a so cause notice under section 148A1B, my lord. 148A1. Asking me that there is a discrepancy because you have filed the return, your lordship will find page 39. And well, this is the PAN number which has been quoted, which was never applied by us, my lord. Initially, this notice was not served. Thereafter, my lord, this notice was served upon our email, registered email ID. My lord, we made a detailed reply, my lord. Your lordship will find page 42, stating all the facts, my lord, page 42.
Yes.
That this is the turnover, my lord, which has been disclosed in the GSTR 1 or GSTR 3B using the earlier GST registration number. Since this PAN number was linked with that GST registration number, so but we are, my lord, always filing the return using the PAN number which has been issued by the Telangana, my lord, Andhra Pradesh, and our turnover has been duly declared. Therefore, there should not be a double assessment, my lord, or the reopening, my lord. the authority, my lord, what happened, my lord, your lordship will find the return also, page 2021. My lord, page 45. Returns was also filed for, using the Telangana address, my lord, and the PAN number issued by the Andhra Pradesh. Now, my lord, kindly see the proposal which has been sent by the authority, my lord, to the specified authority. Your lordship will find your lordship will find the proposal at page number, my lord, page 122. We filed 2 replies, my lord, and along with the supporting documents, all the returns were filed, my lord. Kindly come to 122, my lord.
122. Yes.
My lord. Your lordship got it, my lord.
Yes.
122. My lord. Here, kindly see the top, my lord, at the top. Performa for approval by the specified authority for issuance of the order under section 148A. Kindly see serial number 13. Whether any reply received from assessee under section 148A2. If yes, date of reply, no. So, my lord, authority, my lord, issued this, sent this performa for approval without, my lord, disclosing my reply. Now, my lord, based on this, my lord, performa, the specified authority granted, my lord, approval for reopening of the assessment. So, my lord, he did not apply his mind, and the facts which has been placed by before the authority, my lord, specified authority were not correct. And my lord, if any order is passed based on incorrect facts, my lord, that is illegal, my lord, and unlawful and not tenable, my lord. Now, my lord, kindly see there a reference of the reply which has been given in the 148A3 order that I have filed the reply, my lord. Your lordship will find reference of reply, my lord, at page. So cause notice is at page 149. My lord, kindly see page number 138. In response to the so-called notice dated such and such, last paragraph, my lord, page 138, my lord. 138, my lord. Your lordship got it?
Yes.
Para 4, my lord. Response of the assessee. In response to the so-called notice dated such and such, the assessee did not file. However, the assessee filed its submission on 31st May 2025 to the departmental email office of ITO. So it is an admitted fact that we filed the reply and it was taken into consideration. But when the performa was forwarded to the specified authority, authority says that we have not filed the reply, and based on that, my lord, contention, the authority, my lord, the specified authority granted the approval. Well, I rely upon one judgment, my lord. If the officer has the specified authority passes an order, my lord, without applying in his mind or on incorrect facts, my lord, that order should go, my lord, at pace. My lord, may I request my learned junior, my lord, to hand over the judgment of the Bombay High Court, my lord. German Remedies Limited. German Remedies Limited. Para 24, my lord. It is not in dispute that assessing officer on 15th September 2003 had himself carried file to Commissioner of Income Tax, and on the very same day, rather some moment in the presence of the assessing officer, the Commissioner of Income Tax granted approval. As a matter of fact, while granting approval, it was obligatory on his part to verify whether there was any failure on the part of assessee to disclose full and true relevant facts in the return of income filed for assessment of income of that assessment year. It was obligatory on the part of the commissioner to consider whether or not power to reopen is being invoked within a period of 4 years from the end of the assessment year to which they relate. None of these aspects have been considered by him, which is sufficient to justify the contention raised by the petitioner that the approval granted suffers from non-application of mind. In view of the above matter, the impugned notice and consequently the order justifying reasons recorded are unsustainable. Now, my lord, I am also relying upon the Honorable Supreme Court's judgment, my lord, in the Sara India, my lord. May I request my learned friend, my lord, to hand over the copy of the judgment, my lord, Sara India. Para 6 of the judgment, my lord, kindly come. my lord, last but para 6, my lord, a bare perusal of the subsection 2A of the Act, my lord, these are not relevant. Well, kindly come to, there is no gainsaying, last 3 lines, my lord. There is no gainsaying that recourse, my lord, para 6, last 4 lines, my lord, of that judgment. There is no gainsaying that recourse to the said provision cannot be had by the assessing officer merely to shift his responsibility of scrutinizing the accounts of an assessee and pass on the buck to the special auditor. Similarly, very important, the requirement of previous approval of chief commissioner or the commissioner in terms of said provision being an inbuilt protection against an arbitrary or unjust exercise of power by the assessing officer casts a very heavy duty on the said high ranking authority to see to it that the requirement of previous approval envisaged in the section is not turned into an empty ritual. Needless to emphasize that before granting approval, the chief commissioner or the commissioner, as the case may be, must have before him the material on the basis whereof an opinion in this behalf has been formed by the assessing officer. So, my lord, these materials which I filed in an objection, whether my objections were, my lord, acceptable or not, my lord, it was not placed before the higher authority, my lord, for before granting approval. Now, based on that wrong, my lord, this remark made by the assessing authority, my lord, the specified authority passed order. Now, my lord, your lordship will find, kindly come to the order once again, my lord. What he did, my lord, your lordship, now, since your lordship is dealing GST matters, the lordship knows that in the annual return, there is a consolidated figure of GSTR 3B. My lord, your lordship will find how this addition has been made, my lord. Kindly come to page number, my lord, 137. 137. Yes, ma'am. Here your lordship will find the annexure was given that sales reported in GSTR 3B 22 crore 57 lakhs. Thereafter, your lordship will find turnover as per form GSTR 9C 23 crore 56 lakhs. Purchase on supply as per GSTR 1 5 crore 92 lakh. Turnover as per GSTR 9C 23 crore 56 lakh, which is, my lord, same as noted at serial number 2. GSTR 9C part 2 5A and here the part 2 5N. Repetition of the, my lord, the same turnover appearing at different columns, my lord. And GSTR 3B, my lord, we have disclosed some lesser figure which were reconciled in the, my lord, GSTR 9 annual return. Now, what the authority did, my lord, he added back all these figures, my lord, and considered that this is the income escaping assessment. So, there is a totally non-application of mine. All the figures cannot be added back, my lord, even if it is considered, then, my lord, only the GSTR 9 figures should be considered. Because, my lord, GSTR 3B's figure were reflected in GSTR 9, my lord. That is annual return, and GSTR 3B is the monthly return, my lord. Now, your lordship will find in the last page, my lord, of the order itself, 148.3. Para 6.4, my lord, page 143, my lord. 143, my lord, page number. Therefore, 6.3, my lord. Therefore, considering insufficient response, the only inference that can be drawn that the assessee has nothing to say in this regard, the transaction in question, alleged fund received or brought back information available on record, in view of the fact that the circumstances of the case, the material available on record vis-a-vis assessee's insufficient submission, countering such allegation, the only inference that can be drawn that the transaction in question and its genuineness is under serious doubt, and apparently sham and transactions were brought through some manipulative arrangement and a quantum of rupees 76 crores, my lord. GSTR 3B figure, GSTR 9 figures, my lord, appearing at 2 places, and thereafter the purchases and other income. All these things were added, my lord. There is totally non-application of mine, my lord. Before invoking, my lord, section 148A jurisdiction. And, my lord, since it is a case of double pan, my lord, I never use that pen, my lord. Now, my lord, this turnover which I have disclosed in GSTR 9 and the GSTR 1 has been duly, my lord, disclosed in my annual income of return, my lord, disclosed by using the PAN earlier issued by the Telangana, my lord, Andhra Pradesh Income Tax Authority, my lord. So, my lord, it will be a double taxation on the same income, my lord, if it is allowed to be added, my lord. So, what I am requesting before your lordship, my lord, kindly direct the authority to take into consideration of the, my lord, returns which we have filed using the earlier PAN, that PAN which we have applied and we have used for all along the years, my lord, since 1980, and, my lord, thereafter decide the issue.
Yes, Mr. Sharma.
My lord, there are two PANs, admittedly. There is no denial by the assessee that he did not have two PANs. In fact, the second PAN was thought to be cancelled only after these proceedings that has been made part of the PAN. And this reopening proceeding 148, this is initiated for examining the transaction made through second PAN. And in respect of second PAN, no return was filed. So whatever transaction has been
If the transactions which are reflecting in respect of the second PAN that have also been accounted for in the return filed in the
these
first
are
PAN.
questions of fact.
So that is what is to be that is what is to be considered by the assessing officer when he files the reply. The consideration is not there. Where is that consideration that it is his case that all those transactions were reflected? I reopen
my lord, I have-
immediately. That is not the thing. I have been repeatedly saying this. You have to see whether those transactions which were reflected in the earlier PAN, if they have been considered in this PAN, he will not be doubly taxed. No? So how has that consideration come? Where is that? So he will examine at this stage only if the returns are available. What more is required? Unnecessarily, you will continue the proceeding for money.
What is the purpose of this proceeding, my lord?
The purpose of this proceeding is to see whether reopening is to be done or not. Now, if reopening is to be done, it has to be done in accordance with law. What is the law? That income has escaped assessment. Income will escape assessment if the return does not disclose it. If the return has disclosed it, can you still say that income has escaped assessment?
PANs, my lord.
So those PANs, that is his submission, that I have made this submission that the transactions which are reflected in the earlier PAN have also been disclosed in the ITR filed through this PAN. If that is the only case that there is two PAN, there is a transaction reflected there and that has escaped assessment. If you find that that has not escaped assessment, you pass an order appropriately. You reopen that yes, even after this, there is escapement of reopening. Who stops? But then whether that consideration has been done or not, definitely that has to be seen.
And para 12, my lord, of the writ petition, I have my lord, specifically said your petitioner submits and states para 12 of my writ petition at page 10.
Where in your reply, Mr. Dugar, where in your reply have you said that the transactions which reflect in respect of the earlier PAN are taken into consideration in the ITR
Yes, my lord.
filed in respect of the current PAN?
Yes, my lord. Kindly come to my reply, my lord. Your lordship will find at page number, my lord, 144, my lord, page 44.
Page?
44, my lord. No, I'm sorry, 44. My lord. Not 44. It's not 44, my lord. I'm sorry.
We'll continue tomorrow then.
Yes, my lord. I'm sorry, my lord. I will appear physically, my lord.
Mr. Sharma, what about that reply?
Reply, my lord. This response was given to on the email ID of the assessing officer.
Page 42. Page 42, my lord.
I had.
My lord, I don't. I'm.
To appear
My lord,
when the assessee had made response, not on the portal. This
my
point
lord,
was.
I am not aware, my lord.
The matter. So,
my lord, I am not aware whether any other PAN was still existing.
Not given on. What will happen, my lord? These approvals are on system based. If the response is uploaded on the portal, it will reflect that there is a response. But it is not. If not uploaded, it will show that there is no response. But my lord, It is not the case that his response was not considered.
No, he's a step ahead. He says that the approving authority did not have the benefit of a pro forma where right facts were declared to him. Therefore, he approved on a pro forma saying that the assessee has not responded. So,
My lord, can you
this
see the
point is not
this,
something which can be
page
improved
123, my lord?
When I am passing an order of approval, I will pass an order of approval based on
Brother,
whatever is presented
Bring
before
it.
me. You present before me that no reply was received. I have seen this. I said, no reply is received, approved. Then
My lord, they have
what
said
is the
the
problem here?
my lord, the approving
that is
authority has
something which-
said, my lord, in column 16, that I have perused the case records.
Case record means what? Case record means what? It may include the reply.
Only
to
an
other
Excel was
documents.
filed.
Then that becomes again a difficult situation.
So
Case
then
records, Mr. Sharma, the more we dig, the more problematic it will become. Case records will include the reply.
My lord.
If he has seen the case records, then he should have corrected this no, at least by hand. If he has seen the case record,
My lord, it is
if he has seen the case record, then he ought to have said that no, this is not right, or he should have added a corrigendum. It is not that simple. If a point is raised, it has to be answered. On that side, it is different. On this side, it is different. I have to be taking a balanced approach. I cannot do what I was doing there. So don't equate those things.
My lord, these
Since the
questions,
example that you gave, that was a different role.
my lord,
This
these
is a
questions
different
are
role.
arisen in several cases, my lord, where these whether response has been filed or
Not,
not.
Mr. Sharma, if no question is raised, it is all right. The moment a question is raised, it will have to be answered in accordance with law.
These question has been raised in several cases. My lord.
But not in the way in which it was raised now.
No, no,
I have also
similarly-
faced it.
similarly,
No,
my
no.
lord.
The question raised here is that the the specified authority has not taken into consideration because what was placed before him was this, and in both ways it is doing so. It becomes difficult. You go through the record, see if his reply contains that the
Then my lord,
transactions in
I will
respect
have
of
to
the
take
earlier fan.
instructions, my lord.
Take
From that,
instructions.
my
When?
lord. I will
When?
come back with after a week, my lord.
After?
Week.
After a week, he wants.
Yes, my lord, that will do, my lord. Both the matters, my lord, 10 and 11, same, but different assessment here, my lord.
10 and 11.
Yes.
ना 10 सर ऑर्डर पास करूं 11 तो सुनी नहीं चलेगा 10 लिखूं heard Mr. Dugar, learned advocate, appearing for the petitioner, and Mr. Sharma, learned advocate, appearing for the respondent revenue authority. Full stop. अच्छा तार ऊपर एक्चुअली लिखे देंगे सर दुटो लाइन this writ petition appeals an order passed under section 148 capital A within bracket 3 of the Income Tax Act, 1961, and the consequential notice under section 148 of the said Act of 1961, issued in respect of assessment year assessment year 20-21. আচ্ছা আর consequential notice order দুটোরই ডেট বোধহয় একই থাকবে June 20, both dated this writ petition says such and such notice issued under such and such তারপরে in respect of assessment year such and such both dated June 20, 2025, inter alia on the ground that the same have been issued without proper application of mine to the petitioner's reply and the material on record. Therefore, heard such and such list as Mr. Sharma seeks some time to take appropriate instructions. List this matter for further consideration on 10th, 1 week, on February 10, 2026. এই পরেরটা এমনি 10 তারিখে অর্ডার করতে হবে না মিস্টার দাস মিস্টার হি ইজ দেয়ার ইন কোর্ট পরেরটাও সেম অর্ডার রেকর্ড করে দিন শুধু what is the assessment year in the assessment year and date of notice?
Number 4,
Assessment year is 21. 21, 22, my lord.
He's mute. Mute, sir. You are on mute, Mr. Dugar.
My lord, 21-22.
Assessment year 21-22 and date of notice?
My lord, I'm providing, my lord. Just
140th notice is, my lord, 20th of June, 2025.
No, 28th of June was the earlier one. This one also same notice. Same date.
same.
170.
number 4, Your Lordship, Your Lordship, I am in some difficulty today and tomorrow and day after. If Your Lordship can kindly keep it on Monday, subject to Your Lordship. He's,
4 number itemটা সোমবার করে দিন।
I'm deeply obliged.
4 number. Thank you.
I'm grateful, my lord.